Itu luar biasa. Nanti ikna itu pas part foto dia kali. Pada part itu kita ada. Nah, sini ada. Tadi na, kita tadi itu tadi sih. Part here tadi tadi sih. Oggi continuo allora che non lo già da kita pemilih nah tapi kemudian berperan tadi Facebook tapi kami juga dua saya tang mix Korea lah saya itu bisa minta nomor ini dia tadi dia Indonesia macam ni itu kita itu kita benar dia dengan
May I please, Worship?
Yes.
Worship, I'd like to mention for item number 9.
Item number?
19. Item number 19. 19. 19.
Yes.
This condemn was filed for non-compliance to the order dated 16/6/2015, passed in the WPC number 217 of 2013. Worship, against this judgment and order dated 16/6/2015, the University Grant Commission, they have filed an appeal before the division bench. The appeal was dismissed. Again, against the dismissal of the writ appeal, they went to the apex court. The apex court also dismissed the ACLP. Only after the dismissal of the ACLP, this condemned petition has been survived. So during the meantime, the present condemner, they have already retired. In the new incumbent, they have come. So I have to issue a fresh notice to the new incumbent. And by highlighting all these facts, I want to file a fresh condemned petition by withdrawing the present condemned petition.
So you want adjournment?
No, Rashid, I want to withdraw this present
Oh, you
contempt
want to withdraw the petition?
with liberty to file a fresh petition.
Okay, okay.
Since all the facts has to be incorporated.
Okay. Heard, Mr.
Lima Wabanshi.
Learned counsel for the applicant. The learned counsel for the applicant submits that he has the instruction to withdraw this application with a liberty to file a fresh one. Pair is accordingly allowed. This petition is then disposed of on withdrawal.
With liberty to file a
With
fresh
liberty to file fresh.
obliged.
May I please, my lord, lordship, item number 21, on behalf of Miss V. Chokre, additional AG, lordship, may be listed after 4 weeks, lordship.
On the pair being made by Mr.
Kiangami, lordship.
Learned counsel for the learned counsel, appearing on behalf of
Miss V. Chokre, additional AG.
learned counsel for the applicant, list the matter after
4 weeks, lordship.
4 weeks.
Bless you, lord.
Please, my lord. Lordship, I may be allowed to make a mention for item 9.
Item?
Item 9, I have the consent of the opposite counsel.
Item number 9,
Yes, my lord. If you can kindly come up with 3 weeks.
after
3 weeks, my lord.
you are for the petitioner,
Yes, my lord, I am for the petitioner.
Mr. Your good name,
Cindy Amar, my lord.
Mr. So-and-so, learned counsel for the petitioner with consent from the other side, press for listing the matter on after
3 weeks.
3 weeks, pair is allowed. Is there any interim?
No, lordship.
No.
Bless my lord. There is interim, but the interim it is absolute.
Made absolute.
It is
But-
absolute.
Okay.
Keeply obliged.
Lordship, I would like to mention item number 3. My senior is out of station, YB Gupta. Kindly the matter be listed after 4 weeks.
Who is your senior?
YB Gupta, out of station.
Item number 3,
Yes,
your good name,
S. Imli.
Mr. So-and-so, learned counsel appearing on behalf of Mr. So-and-so, learned counsel for the petitioner.
Lordship, I Is for respondent. I'm for the petitioner.
Respondent.
Acha. Learned counsel for the respondent with consent from the other side, press for listening the matter after
After 4 weeks.
4 weeks. Fair allowed. Is there any interim order?
No, Your Lordship.
No. Okay.
Lordship, I may be allowed to mention item number 24 on behalf of Mr. Tayyip Juba.
24.
24. Lordship, the council has some difficulties, so the Lordship may kindly let the matter come up after 2 weeks, Lordship. 24.
Mr. So learned counsel, you are here for petition or no appellant?
The appellant.
Learned counsel for the appellant. Press for listening the matter after 2 weeks.
2 weeks, Lordship.
Fair allowed.
Obliged, my lord.
Please, Your Lordship. Lordship, I beg to mention item number 12. Kindly grant us 2 weeks' time to file affidavit in opposition. I'm for respondent number 1.
Your good name?
K. Lilisu,
Ms. So learned counsel appearing for the respondent number 2,
1-1.
respondent number 1. You inform the other side?
No, Lordship.
Lordship, I'm for the petition alone.
You are for the petition. So you have any objection?
No, Lordship.
With consent from the other side, press for listening the matter after
2 weeks.
2 weeks. Fair allowed.
Much obliged.
May it please your lordship, I beg to mention item number 11. Your lordship, may please grant 3 weeks time for filing of additional affidavit
You are for?
for the petitioner.
Ms. So learned counsel for the petitioner submits that she may be granted
3 weeks time.
3 weeks.
Yes.
3 weeks. 3 weeks time to file additional affidavit. Pair is accordingly allowed. You inform the other side
Lordship.
Yes.
Lordship.
with consent from the other side. Press for listening the matter after 3 weeks so as to enable her to file affidavit, additional affidavit. Pair is allowed. Okay.
Please, your lordship, I beg to mention item number 10. I am for the sole respondent. I will be allowed 2 weeks time.
No objection, Lordship.
Acha. Mr. I Im Song, learned counsel for the sole respondent with consent from the other side. Press for listing the matter after 2 weeks
2 weeks.
so as to enable him to file affidavit in
Opposition.
opposition. Pair is accordingly allowed.
Lordship is interim. Can you let him continue?
Till then interim order shall continue.
Obliged, my lord.
For admission, item number 1 and 2.
Lordship, this matter can be taken up for final disposal.
Today,
Yes, Lordship, if the court.
acha.
Yeah, parties are also represented. All the parties are represented.
Acha. Okay, argue the matter then.
Lordship, yes, Lord. Lordship, may. Lordship, there are 2 matters here. Item 1 and 2. They are analogous in a sense that both pertains to the same subject matter. Lordship, the fact is, I was compelled to file the second petition because in the first petition, when the first petition was filed, the impunity was not served upon me. Now, after filing of the first petition, that is the Civil Revision 5, thereafter only I was served with the impunity order. Then I was compelled to file the second
one.
petition. Yes, so that's why the 2 petitions. The facts are the same. Lordship, the facts are that there was a dispute between. What? Who is the?
Yes, any problem?
Lordship, the government is also a party, but the council is not present. But then my humble submission would be, Lordship, the government is not that necessary now. Because of the settled position of law that I will be relying on. So, may I continue? So, Lordship, initially there was a plot of land which was gifted to me by my grandfather. Now, after 2016, the private respondent, the opposite party, started claiming that piece of land. And in fact, they started constructing a
The
small
land was gifted to you by your
grandfather.
grandfather. Yes.
So the opposite party started encroaching on the land. So we filed a complaint before the village council. This is a village land law. So we filed a application before the village council, and the village council, on hearing all the parties and on visiting the disputed area, decided the matter in my favor. Lordship, apparently, after the village council passed its decree, the opposite party went on an appeal before the Vashi's court, Kohima. And the Vashi's court, on hearing all the parties, passed verbally announced that on the spot that the respondent for was the sole actual owner. That was the case. Now, Lordship, after the conclusion, the petitioner, the revisionist waited for the outcome of the final judgment in order, but none was forthcoming. So we approached the dubious court with an application for providing us with the impugned judgment, but it was not furnished to us.
So as a Gauhati court has decided the issue in favor of the respondent.
Yes. In fact, he reversed the judgment of the village council.
Reversed. So you have approached for providing you the copy of the judgment.
Yes.
The same was not provided to you.
It was not provided. In spite of my application, I applied through my application, which I will refer to in my petition. Lordship, after that, civil revision 5 was filed. And on 28, the revision petition was filed. On 29, I was served with a copy of the impugned judgment. Now, in the second petition, there is the impugned judgment. Twenty-six is the local, and page 27 is the translated copy of the order.
And page number
27, no?
27.
Page 27.
Annexure 6.
Yes, of course. And 27 is the translated copy, Lordship. And in fact, Lordship, in this impugned judgment, in decree, a stranger to the dispute was awarded.
Was
Awarded the decree was awarded in favor of a person
stranger.
who was never a party to the proceeding. Lordship, I'll just read in political case number 5 of 2020, Srimati Kitoke versus Nikritono, that is the appellant. The Deputy Court, Kohima, gave a verdict on 2nd March 2021, which was signed and accepted by Srimati Ketoke. However, Srimati Nikitano neither agreed to the verdict nor made an appeal. As such, in accordance to the verdict given by the previous court, the disputed lane is now given to Srimati Ketoke's brother, Lordship, Mr. Neil Hole. So Mr. Neil Hole was never a party. Lordship, in fact, in the village court, the dispute was between me and my two sisters with the respondent. And it was apparently it was the respondent who preferred an appeal, but no memo of appeal was ever finished to us. And after the decision, and they are talking about putting signature in the order, but no order was passed. No written order was passed. Only a mere pronouncement on the spot. So signing of and accepting the judgment does not arise because we cannot imagine to sign any verbal order. Lordship, now I will refer to a judgment of this High Court. Under the rules, Lordship, the rules for administration of justice and police in Nagaland, 1937, there is no appeal provision before the previous court from the decision of the village court, because both of them have concurrent powers. Lordship, the same has been decided in the first edition, page 26 and 6.
26.
Yes. In Civil Revision 5 of 2020.
Page number 26.
Yes, page 26, and it says 6.
Yes.
Lordship, this judgment was passed on reference. Lordship, there was two divergent views as regards the power of the previous court under the rules. There was earlier decision which states that the previous court is an appeal can be preferred before the previous court. But in another case, this was there was a divergent view. So a reference was made, and the reference court decided the matter. The first paragraph at page 28.
Yes.
The present matter has been placed on reference before this bench by the motion of an order dated 21/2/2010, passed by the then Honorable Mr. Justice N. Kodishwar Singh and presently the Honorable Acting CG of this court, which received the assent of the order of the Honorable Chief Justice of India by his order dated 13/5/2008 to place the matter before available bench at Kohima. The relevant bottom is para 8, page 30.
Yes.
There were two issues raised before the court. One is whether any decision passed by the village court can be heard on appeal by the Pashi's court. Second is whether Office of EAC or Assistant Commissioner can be equated with the Office of Additional Deputy Commissioner, as has been held by the learned single judge in Civil Revision 9 of 17. Lordship, that was, we are concerned with one. So whether any decision passed by the village court can be heard on appeal by the division court.
Yes.
Lordship, after discussing various matters at length,
Hmm.
33,
Where is the finding?
yes, Lordship, I'm coming to it. Page 33, para 16.
Yes.
Lordship, in the second part, para 16.
Hmm.
Thus, the plain reading of the provisions of Rule 31 does in any way give authority to the PC or its assistant for cases of appeal to any court, any other court, but to the Panchayat. Therefore, an appeal forwarded to the Court of Gauhati from the decision of the village court is to host the provisions of the appeal rules of 1937 Act. The Rule 31 is crystal clear that when appeal is preferred from any of the master, chief, headmen of trails to parties or other duly recognized village authority, it will, if satisfied, enforce it as its own. If it has reason to doubt, it will either try the matter de novo or endorse it to the Panchayat. Worship, going further to 34.
Yes.
Lordship, after citation of the rules, the above provisions of the Lordship provides that the Vashi's court in the village court, including all other courts below the assistant to DC, have concurrent powers. Lordship, I think this is a spelling mistake. So, have concurrent jurisdiction. And 35 law. I'm just reading the relevant portion now.
Yes.
Therefore, the reading of these two rules also lends support that the Court of Appeal against the decision of the village court shall be the district customary court and not the village court. And para 20. From the above discussion, we hold that Rule 31 of the Rules of the Administration of Justice and Police in 1937 does not provide for appeal against the decision of the village court before the DPS court.
So your contention is that this Gauhati's court has no
Jurisdiction.
jurisdiction
Yes.
to hear an appeal against the order passed by the
village court.
village council.
Yes.
That is your contention.
That is the only issue involved. And in the absence of the power to entertain the appeal, he could not have decided the matter and in fact degraded the disputed land to a stranger who was never a party before any of the proceedings. So that is the only issue involved in this matter.
Okay.
Whether the court of the Vashis, in fact, Lordship, the Vashis have no, in my mind, I believe, original jurisdiction over Fatadna.
Acha.
They cannot decide on any matter. Lordship, earlier, the notion was that the assistant to DC, the DC or the assistant DC could endorse the matter to the Vashis. But now, as it stands, the DCs or the assistant to DC also cannot endorse the matter to the DC. If the matter relates to a decision by the village court, because all have concurrent jurisdiction. And Lordship, unfortunately, in terms of the rule, no district customary court has been established as yet. That is the position. Therefore, the only option for the respondent would be to file an appeal before the DC or his assistant against the decision of the village board. And in the present case, this was not done. In spite of our effort, Lordship, we approached the village board asking for documents. No documents were finished. No memo of appeal was also, any application for that matter was finished to us. So I don't know whether, how come the appeal was heard by the village court also. But because I was issued to summon and I was summoned before the village board, I went and participated and give my version.
Yes, so who is for the state?
Your Lordship, I'm for respondent number 1 and 2, but your Lordship, the respondent number 1 and 2 it's not a necessary party. So
Not a
has
necessary
nothing much,
party.
it's not a necessary party, has
So
nothing
you
much
have
to
nothing
say.
to argue.
Yeah, except that your Lordship, the aggrieved party have to approach the appropriate forum, that is.
Yes,
My lord, I'm for the respondent number 4 and 5.
yes.
In
Respondent
terms,
number 4 and 5.
yes. In civil revision number 8, I'm for respondent number 4 and 5, and in civil revision number 5, I'm for the respondent number 4. Because in civil revision 5, the respondent number 5 is not impleted. In the subsequent petition, only the respondent number 5 was impleted. The issue is regarding only the jurisdiction of the Dupashis court, whether the appeal lies to the Dupashis court against the order passed by the village court or not.
But this order.
Yes, my lord.
This order.
Yes,
It is clear.
since this honorable court has already decided on the issue. And then as regard the written order by the Dupashis court, since my learned friend has said that no order has been furnished to him, but as per Rule 36, all proceedings shall be viva voce, not in written. That should cover case regarding the order. My lord, since this is only the covered case regarding the jurisdiction of the Dupashis court, since this honorable court in WBC 164 of 2027 by order dated 19/6/2023 has also held that the Dupashis court has no jurisdiction to see as an appeal against the order passed by the village
No,
court.
in this
So,
judgment also it has been held.
yes, in
No,
the
but,
same case, same case.
There is already a division bench judgment.
Yes, same case, in the same case. This is a subsequent order in the same case, which was referred to by my learned friend. This is the same case, subsequent order. So my lord, in view of the, since it is already the covered case, my only prayer is that I may be allowed to approach the appropriate forum, that is the deputy commissioner, by way of an appeal. And then the delay goes in, there's a delay because like if I have to approach a deputy commissioner, the delay may be.
No, that is provided in the Limitation Act.
Yes.
Yes,
itself.
Lordship, not necessary to be mentioned in your Lordship's order. That will
Because
come in the appeal.
No, it is already provided in the Act itself.
Yes.
Limitation Act. So no order is required.
Yes.
You simply quote the provision.
Yes, so in view of the order passed by this lower court, as also in view of the provisions of the Prince White Minister of
We will
Justice.
pass the order.
Yes, my lord.
Yes. Next item.
Oh.
Item number 3 to 8. Item
No,
number
no,
3.
three has already been mentioned.
Already. Item number 4 to 8.
May I please, your Lordship? Your Lordship, this revision, review obligation filed under section 114. Yeah. Against the command judgment and order dated 29, 2019. That is, there were related repetition bearing WPC 237 of 2018. Or let me come in the serial wise. Your Lordship, here, this application has been filed under Order 47, Roll 1, read with Section 144. Even though there is a very limited scope in the review as per the Code of Civil Procedure 1908, but here as per the section Order 47. Order 47, Roll 1. Here it is clearly mentioned that we have not, against the command judgment, we have not made any appeal. But after getting the judgment, we have discovered some documents which could not produce during the proceeding of those analogous repetition. So under this Rule 47, as per the provision, if something evidence is discovered, then we are coming under that. And as per the chapter 10 of the Chapter 10, Rule 3 of the Gauhati rules, then there also same thing has been. We have discovered some fact, some evidence in connection with the disposal of matters. So for which this review petition has been filed. Your Lordship, here, review petition 6 of 2022. It is arising out of WBC 237 of 2018. It's all analogous. And review petition 7 of 2022, it is arising out of WBC 201 of 2017. Then last one, review petition number 8 of 2022 is arising out of repetition number 202. So Your Lordship, here that we are approached the Honorable Court in connection with the
So what is the ground for review?
Your Lordship, here, the crux of the review is those petitioners, they were the work-class employees in the Power Department.
Yes.
So at the number those 2-3 analogous petition was pending, the state respondent could not produce that their benefits earned during the work-class period was not included. That fact could not be brought to the notice of the court. So after getting the judgment, and as and when the department gone to the record, so it discovered that those all the respondent, opposite party, petitioners and those repetition, they have already given that the benefit under the ROB 1993. So it could not be brought to the notice of the Honorable Court. So for which we are compelled to file this review petition. And again, Your Lordship, here, this review, it is again another contempt petition is already there. So let me just clarify at one go that COB 6 of 2022. Of course, first, initially the contempt was moved, followed by the review petition. But Your Lordship, here, in this matter, the command judgment was passed on in the month of November 1919. And the Honorable Court has given a direction to consider the case of the petitioner within 5 months. So followed by the, during the process, again, by 2020, 23rd March, the Honorable Prime Minister had declared national lockdown, followed by the national lockdown. So in the process, we could not complete those case of the petitioners during that stipulated period as directed by the Honorable Court. So in spite of all those difficulties by those SOB and all, somehow we managed to check the record. Then later, subsequently, we discovered. So in the process, as and when we try to comply the direction of the Honorable Court, in the process, fortunately or unfortunately, the contempt came. So in the contempt, it doesn't mean that contempt, we have to see from two grounds. The the contemporary who sleep over the direction, then
No, now we are not concerned with
no,
that.
no, no, since it is connected, it is connected. So that is a thing. So my submission is that even though it is clubbed with a review application, the contempt, so there is no intentional disobedience or disregard of the honorable direction of the honorable court. So I'll come to the review. That particular part, that is only that portion in all the, it is analogous, we focus on that the benefit earned by the petitioner during the work rest time. It is already included in the ROV 1993, and for which Annexure 5 of our review application, that is additional documents. Annexure 5. Here, Your Lordship, I will be allowed to read Annexure 5 to my review
Which
application.
petition?
I'm in review petition
Item,
6.
Review petition number 8.
I'm in 6.
Annexure,
Annexure 5,
page number.
page number 136. Your Lordship, here, this in Annexure 5, we have reflected one employee petitioner, and in the review application she is the respondent number 16. So it is clearly pointed that Your Lordship, let me allow to read the contents. Y Akala, bail assistant. She is the respondent number 16 in the review application. As one of the petitioner who was appointed in the year 21 February 1987 and was enjoying the scale pay under ROP rules 1993, that is 1150-30, 1450-35, 1800-40, 2120. Her last basic pay prior to her regularization and the last ROB 1993 was 1660. The petitioner was regularized with FF from 1st January 2012. And since she was regularized when the ROB rules 2010 was implemented, her taxation was subsequently converted to the corresponding scale starting from ROE rules 1993 to ROB rules 1999 and then to ROB 2010. Taking into account all the increments earned during her work-charge services period. Hence, upon the regulation, her basic pay was fixed from 1660 as per the ROB 1993 to rupees 7960. Since the question of adding all the increments earned during her work-charge service upon regularization is irrelevant and does not arise as and when the department has already been exercising for fixing of her pay and allowances by counting all the increments earned during the work-charge service as per the relevant rules. The last pay certificate can be summarized below as on 1st January 2012. Basic pay 7960, TA 65% as on 1st January 2012. Then it has to be multiplied by 7960 into 65%. It comes 5174. So gross salary comes 13,134. So similarly, we have also annexed that is in the page 37, 138. Mr. Ominu Izong, he is the respondent number 79 in this application. So that those part we have already worked out and added in the as per the ROB 1993. But the problem with us was that we could not produce all those facts as when the analogous petition was pending before the honorable court. So
whether this petitioner was diligent.
Your Lordship,
He was diligent at the time of while finding out the these documents. See, in the case of Lily Thomas, Supreme Court has laid down the norms in which a review petition can be considered and allowed. So whether any of the provision of any of the laid down procedure in that in the case of Lily Thomas is followed in the case.
No, your lordship here, as
That
per
whether
the,
that judgment is available with you.
no, your
Lily
lordship,
Thomas.
not available. It is not. But you see, your lordship, section 114, that is chapter 8 of the part 8 of the CBC and order for discipline rule 1. So after getting the judgment, if anything, any evidence or something error was discovered, then as per the prescribed law, we have to file the review petition. So that is my submission before your lordship. Then as why we filed this review against this command judgment. That's the only portion which we could not place before the honorable court during the proceeding of the analogous matters. That is my humble submission.
But you do one thing, you produce that judgment, we will see
Okay.
whether this case will be covered by that judgment or not. Lily
Lily-
Thomas case.
Lily Thomas.
Lily Thomas. LILY THOMAS.
Lordship.
Yes, anything from other side?
Your lordship, as of now, I don't even know, say your lordship. Well, because your lordship here, actually it's like this. My facts of the case, your lordship, in short, your lordship. Earlier, the petitioners were appointed as work charge, your lordship, on scale. And then at the time of the regularization, their pay were fixed at minimum. So the petitioner approaches honorable court seeking that, well, fixing their pay, their basic pay was fixed at minimum only. So their increment is to be counted for fixing of pay. And then this honorable court is given direction for national fixation of the petitioners as per the ROP 1993, since the work charges are governed by the ROP 1993. But then now the state respondents, they've come with a review saying that they've granted the increment, your lordship. But the document which the state respondents they have showed, your lordship, it can be clearly seen that my pay was fixed at minimum on, your lordship. Increment was never counted, your lordship. And then there's a notification issued by the chief secretary PNR that if work charge services are continuously on scale and then if regulars, their increments shall be counted for fixation of pay. So that this is the case, your lordship. And then, well, after disposing the writ petition, I filed the contempt petition, and now they come with the review petition. So unless the writ petition is been heard, your lordship, my contempt petition is nothing to do as of now, your lordship. So this is the case, your lordship. And
Okay, then we will hear you day after tomorrow.
Chapter trustee.
Yes. You come with this judgment, Lily Thomas.
Lordship.
We'll try to dispose of the same on that day. Heard Mr. I Insong, learned counsel for the petitioner. And also heard Mr. What was it?
Spongwati.
Chopongwati. Your good name, please?
Yes, lordship, Spongwati.
Acha. Learned counsel for the respondent. Heard in part, list the matter day after Thursday.
As fixed item, your lordship.
Pardon?
As fixed item.
Pardon?
As a fixed item.
Fixed item.
Yes, exciting.
Item number 13 to 15.
Please, lordship. Lordship, I have an instruction to appear on behalf of respondent number 2 and 3. So this matter may come up after 2 weeks, lordship.
Why?
Lordship,
This is a bail
if necessary,
application.
I'll be filing affidavit in opposition.
This is bail application.
Yes,
Why
lordship.
2 weeks?
Lordship, there's a criminal revision filed by the petitioner. Now the respondent wants to clarify some facts, lordship.
That's all right. We can grant you 2 or 3 days time, not 2 weeks.
Lordship, will-
Because Supreme Court has categorically stated that anticipatory bail application has to be disposed of within a period of 6 weeks.
Lordship, in that case, I'll seek instruction, Lordship. Be
What
filing
instruction?
to
What instruction?
file affidavit in opposition if necessary, Lordship. Because the petitioner, the
When
respondent
this
wants
bail
to
application was filed?
make some clarifications.
Yes, who is for the petitioner?
I'm for the petitioner, your lordship.
When it was filed?
The question,
No, this
this
AB
APC was filed on 13/6/2023.
13/6.
2023, yes, your lordship.
So 6 months is about to.
Lordship, I'm mentioning for item number 14, Lordship. There's a criminal revision.
Not in
File.
13.
Yes, Lordship.
You are not in 13.
I'm in 13 and 14, but
No, they're not in
Lordship,
13 and
I'm
14.
appearing in item number 14, Lordship.
What about item number 13?
Lordship, item number 13 is for anticipatory bill. I have no objection on that, Lordship.
No objection
Yes, Lordship.
in allowing this petition.
No, your lordship, in item 13 and 15, they are not parties, they're private respondents. In item 14 is the quashing of the criminal complaint.
No, item
They are
number
parties.
13 is the anticipated bail application.
Yes, your lordship.
Lordship, I'm
In-
only
in
appearing in
this
item.
item number 13, he has no objection.
In that case, my bail may be regularized, your lordship. May be made
You have
obsolete.
already granted
Interim, yes.
interim.
Yes, your lordship, and I'm also cooperating with the investigation.
Yes, sir. CD is available with him. Cassette was called for or not called for?
Lordship, yes, CD is available. Lordship.
CD is available. What is the stage of investigation?
Lordship, still going on.
Is still going on.
Yes, but the thing is, some sort of, though this is an economic offense, they initially, it was, a criminal complaint was filed before the magistrate. And the magistrate has directed for investigation by filing proper FIR. Now the parties have come to a kind of amicable settlement and again.
How it is economic offense? The offenses are registered under section 378, 379.
Your lordship, the case in a nutshell. The complaint was filed on a misconception by the complainant, that is the private respondent in the quashing petition, your lordship, saying that we undertook a project to construct a girls' hostel. And then they were on a misconception that we did not complete the project. The project was completed. The department has issued a work completion certificate to us also, and the fund was released. Now, since a complaint was filed against us, there was a tense situation between the petitioner and the private respondents here. So the people residing over there invited us, summoned all of them, and it was clarified that the building was constructed and the construction is there. Only thing, the misconception occurred because the project was for a girls' hostel. Now, after the completion of the girls' hostel, none of the students showed interest to get themselves admitted into the girls' hostel. So the building was lying vacant. So the government, that is the government composite high school, they utilized 2 classrooms for that for temporarily. And then some of the rooms were used for public purposes. But as and when the girls get themselves admitted, it will be vacated. The hostel. So the entire case was on a misconception, your lord.
Where is the FIR?
During the
FIR is in page 101 of the criminal revision.
Page number 101
of the criminal revision.
Oh, this is the printed form. Where is the complaint?
Complaint is in page 16, Your Lordship.
16.
Yes, Your Lordship.
This revision petition.
Yes, Your Lordship.
And that was forwarded by the magistrate under
Yes,
section
yes.
156.
Yes, Your Lordship, for investigation.
CFPC.
Yes.
And on thereafter, this case has been registered.
Yes. Now, during the pendency of the investigation, Your Lordship,
Mm.
the parties were clarified. That is the private respondent in the revision petition.
Mm.
They were the complainants. And it was clarified, yes, the building was constructed and it is completed. So, on being satisfied, the complainant has filed a withdrawal application, which was rejected by the learned magistrate before the trial court.
Okay, heard Mr. Your good name.
I am Chen, Your Lordship.
Learned counsel for the applicant and also heard Mr.
Kianga, my lordship.
K.
State.
Angami.
Yes,
Learned PP
lordship.
for the state respondent. Number 1. You are for the respondent number 1.
Lordship.
And Mr. Your good name.
Lordship K. Arka,
Learned counsel for the respondent number
2 and 3.
2 and 3. Apprehending arrest. Harassment in connection with TSNUPS case number 0016 of 2023 under section 378, 379, 409, 415, 420, 34, 120 BIPC. This application under section 438 services prepared by applicant Siri Lialo Apon for grant of PRS. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by 1. Joel Naga and Gwalzau Kat on when it was filed Yes, when it was filed?
Your Lordship, that I don't have any idea, Lordship, when it was filed.
No, when the FIR was filed, complaint was filed upon which the FIR was registered.
Filed on 11/5, Your Lordship, 2023.
11/5/2023.
Yes, Your Lordship.
Where it is mentioned?
No, that I was informed from my Your Lordship.
No, you have referred to the printed form of FIR at page number.
FIR is at page 101, Your Lordship.
101. On 29/5/2023. The essence of allegation made in the complaint dated so and so is that the applicant has misappropriated the fund allotted for construction of girls hostel at where? Which place?
K station, Your Lordship.
Pardon?
K station.
Where it is mentioned? For construction of girls hostel building at Candino and Seminio.
The statement is there at paragraph 9 of the revision petition, Your Lordship.
And to cover up his misdeed, he convinced, no, he in connivance with who is accused number 2? In connivance with one John Cut and invested some of the money meant for the said project in the construction of Kandi Public Union Office building located at K Station Place, Shemino District. The learned counsel for the applicant submits that this court by order dated. Where is the order? By order dated 15/6/2023 was pleased to grant interim protection to the applicant. And pursuant to the said order, the applicant had appeared before the IO and his statement is recorded and he has been cooperating with the investigating agency. Therefore, a contention is being made to make the interim order dated 15/6/2023 absolute in the same terms and conditions. On the other hand, the learned additional PP has produced the case before this court and submits that. What is your submission?
Lordship, since in the interest of justice, since they kind of arrive at amicable settlement, I think as far as anticipatory bail is concerned, I will leave it the wisdom of your my lord.
Submits that the matter has been settled amicably between the parties. And what is the stage of investigation
Investigation was going on, Lordship.
going on?
Lordship, at the time of
Whether he has achieved any progress or not?
Lordship, as far as CD is concerned, they say that they say there's a building, but as far as the city is concerned, there's no building structure. But subsequently, to be fair, Lordship, subsequently, as per the understanding, arrived at some adjustment of
No,
monies.
whether they have been cooperating with the investigating agency,
Yes, Lordship.
cooperating,
Yes, Lordship.
and whether their custodial interrogation is required in the interest of investigation.
That instructions I don't have, but I think it may not be required, Lordship, as long as cooperating.
Cooperating.
Yes.
Submits that investigation is still going on, but the applicant has been cooperating with the investigating agency. Pero, having heard the submission of learned advocate, no, also, no, Mr. Yes, and yes, what is your submission?
Lordship, I'm appearing in item number 14, Lordship, in
third-
criminal
13?
revision. I received instruction to appear on behalf of respondent number 2 and 3. But I'm yet to file it, Vakalat number, Lordship.
Acha.
I'll file my Vakalat
Okay.
number in the course of the.
Lordship, as far as anticipatory bail is concerned, I think.
He is not a party here.
No, no, Lordship.
Okay. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record and also perused the case they produced before this court by learned PP. But it appears that the applicant has been cooperating with the investigating agency, and the IO has also achieved some progress in the investigation of the case. And in that view of the matter, custodial interrogation of the applicant seems to be not warranted here in this case. And therefore, this court is inclined to make the interim order dated 15/6/2023 absolute in the same terms and conditions. In terms of above, this AB instance dispose of case there will be returned. And in item number 14, criminal revision petition.
15 is also one of the co-accused, Lordship. So maybe similar order may be passed.
In item 13 and 15, similar common order may be passed. That is the anticipatory bail application.
What is your say?
Yes.
Okay.
Over the same
Same
course of
order.
action.
Same order, yes. In this revision petition then,
Lordship, as far as the revision petition is concerned, I'll be filing my Vakalat number today, Lordship.
acha. Heard Mr.
I intend, Your Lordship.
Learned counsel for the petitioner, and also heard Mr.
KR Khan,
Learned counsel for the respondent number
2 and 3.
2 and 3, and Mr. K. Angami, learned PP for the state respondent. The learned counsel for the respondent number 2 and 3 submits that he will file Ukalatnama during the course of the day and prays for granting him 2 weeks time for filing objection. Pair is accordingly allowed. Lays the matter after 2 weeks.
Much obliged.
Item number 16 and 17.
Lordship here, the leading counsel, my colleague, Miss Esmera is in court one, so if matter, some time may be granted to her, maybe after 1 week, Lordship.
I have a prayer for interim in this case. If we can, I can take it up after tomorrow because Lordship,
Oh, yes, then. Lordship, then in that case, day after tomorrow, Lordship.
Day after tomorrow.
Yes, my lord, because tomorrow the division bench will be sitting.
Yes,
No single bench, my lord.
tomorrow.
Day after
after
tomorrow,
tomorrow.
on Thursday, my lord. Here I have a prayer for your interim lordship.
Okay. As agreed by learned advocates of both the parties, list the matter day after tomorrow.
Lordship, by an earlier order passed by this honorable court, the LCR was called. If I may be kindly allowed to peruse the LCR before day after tomorrow.
Okay, you can peruse the LCM. LCR has been received.
Yes,
My lord.
In item number 20, no, in petition number 29.
29 and 30, they are analogous, lordship. Co-accused in the same case.
Is the ZR case same?
Yes, same GR case, arrested on the same day, same FIR.
Okay.
They are business
Day after
partners.
tomorrow.
Highly obliged, lordship.
Item number 18.
May I proceed with?
Yes.
My lord, this petition under section 482 of the CRPC has been filed on 16th October 2023, and it's continuing. And it is partly heard earlier on 7th November, and it is refused. The court has called for the records LCR from the lower court. It has been submitted, and the court also has directed me to file my citations, which I have also filed. My lord, this petition lies within a very brief facts. The brief fact is this: the petitioner, Mr. Kitako, was arrested by the police on 14th June 2023. And he was remanded to judicial custody on 16th June 2023. After completion of a mandatory period of 90 days, because he was charged under section 21C of the NTPS Act, which carries a punishment of 10 years and may extend to 20 years and with fine also. So mandatory period comes to 90 days as per the police charging sections. So after completion of the mandatory period of 90 days under section 167 subsection 2 of clause 1, the petitioner files a default petition before the special lower court. But the special judge rejected the default bail petitions simply on the ground that mandatory period is 180 days and not 90 days by reading section 36 of the NTPS. This is the only crux of the matters in these petitions. Under section 36 of the NTPS Act, clause 4, it reads in this manner. In respect of persons accused of an offense punishable under section 98 or section 24 or section 27 or of offenses involving commercial quantity, the reference in subsection 2 of section 167 of the Code of Criminal Procedure Code thereof to 90 days where they occur shall be constituted as reference to 180 days. The provision also reads like this: provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year on the report of the public prosecutor, indicating the progress of the investigation and the specific reason for the detentions of the accused beyond the said period of 180 days. This is the only crux of the matter for which petition has been filed under section 482. Yes.
No, where is this order dated 19/9/23?
My lord.
Page number?
I give you my paper book at page 24 and 26.
24 and
page.
26.
Page 25 of my paper book. Page number 25, that is the order of the special court, the last paragraph. The order of the special court reads as thus. Upon perusal of the report, it showed that during investigation, it was ascertained that above two arrested accused bought the seized contraband items from the present accused Kikato, who ran small pharmacy attached to his house at Akuto. Record also shows that the accused Kikato is addicted to SP since 2005, and he used to sell SP smoke capsules by 1,700 to 1,800 per box and 200 per bottle of cough syrup to customers even without prescription from the doctor. In the instant case, the quantity of the seized contraband SP capsule is of commercial quantity, and as such, the recourse of the provision of section 37(1)(b)(2) and DBSF would come into play, and it cannot be said that the accused also is not guilty of the offense alleged against him. Also, as per section 36(4), offense 4, offense involving commercial quantity and is investigated to completed within 180 days period instead of 90 days, as against section 167 of SRPC. As such, I am not inclined to enlarge the accused at this stage. So, the only question here is whether the learned special judge.
No, he was arrested on who is that?
On 14 June 2023. And he moved bail petitions on 14th, the full bail petition under subsection 2 of section 167 on 14th September 2023. The bail petition was heard on 19th September 2023, and this order was passed. This important order was passed, for which I am here before your lordships. My lord, as per section 36A, it is very clear that 180 days can be converted from 90 days to 180 days. That is clear. I am not disputing the power of the special judge to extend the period from 90 days to 180 days. Location of power is due to the special judge very much, but exercise of that power is different from the location of power.
Whether any application was filed before the court below for extension of the period of detention?
Yes, it was not filed.
Not filed.
It was not filed. It was not filed. That is why I objected, but I was not given a chance to make my submissions. And the special was very confident that it is 180 days and not 90 days. And this bail order was passed, which is annexed D. So I am here before your lordship. My lord, yes, power is here, but exercise of that power is quite different from the location of power. Here, civil consequences ensues under section 36A. Civil consequences issue. That is, the court is taking away the precious rights, fundamental rights of the accused to be released on bail, default bail, after completion of 90 days. Section 167 is connected with Article 21 of the Constitutions of India. No person shall be deprived of his life in liberty except.
No, that's all right. All right.
Yeah. So, my lord, it is very clear. Here, charge sheet was not filed on 19th September 2023. Extension of period was not so.
But you have preferred the bail application on 14/9/2023.
Yes.
And the order was passed by learned court below on who is that? 19/9.
Yeah.
And in between, no application was filed by the IO for extension of the period of investigation.
Yes, ma'am.
Yes, Mr. PP.
Oh, Lordship,
the mandatory period is 180 days. Clearly, 180 days, statutory clearly says. If I may be allowed to read again.
You are reading section?
Section 36A, 4, clause 4.
36A.
Yes, 36A, 4. May I read, Lordship?
Yes.
In respect of persons accused of an offense punishable under section 19 or section 24 or section 27A or offenses for offenses involving commercial quantity, the reference in subsection 2 of section 167 of CRPC thereof to 90 days where they occur shall be construed as reference to 180 days, Lordship. And 90 days is to be construed as 180 days, Lordship. Then the proviso says, provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year on the report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days. So the question of the question of application comes only after the statute period 180 days. This is very clear, Lordship. There is no ambiguity. Like in case of Unlawful Activities Prevention Act, yes, what is saying is right. But as far as NDPS case is concerned, there's nothing ambiguity about this. Mandatory period ends only after 180 days. As far as commercial quantities involved, and here the commercial quantities involved, and so there is no any infirmity with the order passed by the session court below, Lordship.
Yes.
My Lord, with due respect to my learned counsel's PP for Nagaland, I object to that. Because as I submitted, shifting from 90 days to 180 days, it produced civil consequences. The right of the accused, the fundamental rights of the accused is being taken away. So here natural justice steps in. My Lord, reading this provisions literally would produce a startling result. Section 36(4)(a). My Lord, we don't have to go into this literal interpretation, harmonious construction, logical constructions of interpretation of statutes. We simply have to look to the provisions, to the judgment of the Supreme Court. The latest judgments of the Supreme Court is Jaspir Singh versus Jaspir Singh Sharma versus Jaspir and others versus National Investigation Agency, Supreme Court of India. It was decided by 3 judges bench. In this case, it is a very interesting case.
You give a copy?
I have already submitted my copy. I will give it. It might be there.
You
Part 1. Yes, my Lord. I've given a flag here, a very important eye opener. Supreme Court has stated this. And eye opener, paragraph 76. And eye opener litigation for the National Investigation Agency, State Police. My Lord, despite of reading the whole thing, let me come to the last paragraph. The law is now well settled in view of the decision of this court in the case of Jikar alias Jimmy Prabhachandra Aditya versus State of Gujarat, reported in 2022, Supreme Court online, Supreme Court page 1290, that an opportunity of hearing has to be given to the accused person before the time is extended up to 100.
No, Mr. Counsel, you see, here, this court deal, no, that court deal with section 43D2B of the Unlawful Activities Prevention Act. Here the case is
Yes,
the
this is,
NDPS Act. Here this
under
36
unlawful prevention activities.
36 capital A, the 36
Capital A.
capital A clause 4 has specifically provided it.
Yes. But this, before extending to 180 days, accused has to be given an opportunity for hearing. And this is usually done not
No,
only.
is it provided in the NDPS Act?
Yes, it is.
Where?
In Bikramjit Singh. My case number 3. N. Ravindran versus the intelligence officer.
Yes.
Para 18. Therefore.
Para 18.
Para 18.
Yes.
This is also by 3 judges bench. Therefore, in conclusion, once the accused files an application for bail under the provision of section 167(2), he is deemed to have availed of or enforce his right to be released on before bail, occurring after expiry of the split time given for investigation. Thus, if the accused applies for bail under section 167(2), shall proceed with section 36(4) NDPS Act upon expiry of 180 days or the extended period, as the case may be. The court must release him on bail forthwith without any unnecessary delay after getting necessary information from the public prosecutor as mentioned. Such prompt action would restrict the prosecution from the frustrating legislative mandate to release the accused on bail in case of bail, default bail by the investigating agency.
No, that is after expiry of 180 days.
Yes, up to 180 days, but even after completion of 90 days also.
No,
this
no.
will apply.
No.
Allow me to interject. This case, there's one point, unless you go through Ravindran case, Bikramji case, Bikramji case referred to, as my lord has pointed out, Unlawful Activities Prevention Act. There in this case, Ravindran case also make a reference to that point. And if you don't read that, the case of the Bikramji, there's a confusion. But the act says, I was also confused since my learned senior friend has been so adamant and made little research, and he researched based on all this and Bikramjit Singh make a reference to Sanjay Dutt case, all this fall under Unlawful Activities Prevention Act. And as my lord has pointed out, for 43D clearly says section 160 DA reference to 15 days, 90 days, and 60 days wherever they occur shall be construed as a reference to 30 days, 90 days, and 90 days respectively. The proviso says application will be made after 90 days. I think so there's a bit confusion here. Otherwise, NDPS at lordship, 180 days
is a mandatory period.
Yes.
In respect of commercial quantity.
Lordship, yes.
So if it is 180 days, then where is your case?
No.
After 180 days, if investigation could not be completed, only in that case the IO can file an application for extension of the period, and court can, after following due procedure, can extend it.
My lord, whether it is from 90 days to 180 days, or from 180 days to 1 year. There
Here, mandatory period of detention is 180 days. Is clause 4 of section 430 36A.
No. Accused again in the whether it is under terrorist activities or NDPS Act, in any case, this has to be read by providing an opportunity before his right to bail is taken away by the court. That is the standing provisions of law. Here, yes, it is written that it is from 90 days it can be constituted as 180 days. But then before doing that, opportunity has been given to the accused.
No, where it is provided? Is it provided in the Act?
No.
NDPS Act.
We have to go behind the courts by reading into that Supreme Court various decisions.
No.
There's various cases.
In the EVPA Act, it is provided, as pointed out by him, 43D. If there is any provision, you show it in the NDPS Act. Will
not only that, my lord, here, as per the FIR Somoto, FIR, lodged by the police, it is, FIR is FIR is at page 18 to 20.
No, first you show us the provision, then we will hear you. And if you want time, we can grant you time. You show the provision. We are ready to hear you. So we will grant you one day time. Yes, after tomorrow we will hear you.
All right.
You show the provision to us. Heard in part. List the matter day after tomorrow as part heard.
Chorus, item number 20.
Yes, Lordship. Lordship, I'm mentioning on behalf of the Council Person number 1 and 2, Mr. Limatushi. Lordship, we have the matter come out of 2, Lordship.
Item number
20.
20.
Lordship, as per the order dated 29/8/23, IA was disposed of with a direction to impede respondent number 4. So we have already issued the notice upon respondent number 4 to registered AD.
As per order dated
29/8/23.
Yes.
So we have already issued a notice upon respondent number 4 on 16/10/23.
Respondent number 4.
Yes, Lordship.
So the service report has not received back. Heard, Mr. You are for the petitioner?
No, no, I'm for the respondent 1 and 2. I'm making mention of
Respondent number one and
Mr. Limao.
You are for the petitioner?
Yes, Lordship.
Heard, Ms. Learned Counsel for the petitioner. And Mr. So Learned Counsel for the respondent number
1 and 2.
1 and 2. And 3. Ms. So Learned Counsel for the respondent number 3. The Learned Counsel for the petitioner submits that pursuant to order dated 29/8/23, the petitioner has already taken a step upon respondent number 4. Office note dated 16/10/23 also indicates that notice was issued to the respondent number 4, but service report is still awaited. Accordingly, it is provided that rest shall list the matter after
2 weeks, Lordship.
After 2 weeks, awaiting service report upon respondent number 4.
Blush, my lord.
Obliged.
Item number 22.
May I please, Lordship?
Yes.
Lordship, I'm appearing for the sole respondent.
That's it.
Lordship, can let the matter come after 2 weeks.
2 weeks.
Lordship, on 5th of October.
5th of
October, LCR was called for, which is also still awaited.
5th of
October.
October.
Yes.
5th of October. What is the pair in this petition?
Lordship.
What is the pair?
Lordship, the petitioner is praying for transferring of the diverse petition, which is in Mokokchung, to transfer to Dimapur.
Mokokchung to Dimapur.
Yes, ma'am.
You are for the respondent.
Yes, ma'am.
You have objection in?
Yes, ma'am.
What objection?
He stationed at Mokokchung, the petitioner. The respondent in this present petition.
Have you filed any objection here?
Yes, ma'am.
When you have filed objection? Take down. Office note dated 10/10/23 indicates that LCR of divorce case number 1 of 2022 has already been called for from the learned court below, but the same is still awaited. In view of above, it is provided that registry shall issue reminder to the learned court below for transmitting the divorce case number 1 of 2022 to this court immediately. Miss.
Lordship, I'm appearing on behalf of my senior Philip Loring.
Miss so-and-so learned counsel appeared on behalf of Mr. Philip
Loring.
And learned Mr. Learned counsel for the respondent number, sole respondent present. List the matter after
2 weeks.
2 weeks.
Please, Your Lordship. My apologies, but I would like to make a mention on the hearing for adjournment, Your Lordship.
Which matter?
Lordship, item number 25, Your Lordship.
25.
25 of the hearing list. Lordship, here I'm for the appellant, but however, the leading counsel isn't disposed So if your lordship allows,
Who is the leading counsel?
the leading counsel is Imna Sinha, your lordship.
Hmm.
Number 2. This matter.
Yes, Mr.
Lordship, maybe fix it on 28 November.
28.
Lordship.
28. Heard, Miss, your good name?
Naksang Tila, your lordship.
Learned counsel for the appellant, and also heard Mr. B. N. Sharma. Learned counsel for the respondent number.
Sole respondent.
Sole respondent. Sole respondent. Miss so and so, learned counsel for the appellant, submits that leading counsel, Mr. Iman Sela,
Imna Sinha.
Imna Senla is indisposed of, and accordingly, it is prayed for listing the matter on 28.
28
28.
November.
Pair is accordingly allowed. Rest shall list the matter on 28.
Much obliged, your lordship.
For hearing. Item number 23.
Lordship, counsel for the item number 23 is busy at court number 1. So if your lordship would kindly.
You are in 23.
No, I am not in 23. As informed me, that
Acha.
counsel for the appellant or petitioner Muaz Amir is busy at court number 1. So instead of this matter, our part third matter may be taken up.
Now,
Lordship.
no,
Supplementary cause list 13.
he has not paid for adjournment today.
Not paid for adjournment,
But,
only inform me that he is busy at court number 1.
Lordship, my senior is on legs in the other courtroom. So if the matter can be taken up after the listed items.
Okay.
Item number 25 to 29. Item number 26 to 29.
Lordship, I am for the state respondent, my lord. The petitioners were here, in fact.
Yes, your lordship. Your lordship grant us a few passover.
Time being? Or for the day?
My senior, he is here, but
Yes.
Lordship, yes. This is regarding a land in Mon District, your lordship, is it? In
Item number 26.
Lordship.
Your item number 26.
Yes.
Yes.
26 to 29, your lordship.
29, it should be your lordship. All these are analogous.
Analogous matter, yes.
The contempt petition arises from the
Acha.
main case.
So you are for the
petitioner
here.
Yes, your lordship. The brief fact of the case is that in 1974, the petitioner's father was a local leader at that point of time, and it was a transitional period. In 1974, within a short time after statehood was granted. So, in recognition of the petitioner's father's human services during that point of time, the state granted him an area of land, the district administration for farming. Now, as time went, within a short period of, at that point of time, the petitioner was still a minor. Then the father expired. Then later on, the state government started, the district administrative officers started allotting land to others, on the land allotted to the petitioner's father. So what happened was the petitioner was running from pillar to post. Then in 2009, the then chief secretary directed the deputy commissioner to verify the allotment of land, everything. And also gave, in the letter of the chief secretary, the chief secretary also mentioned that the previous, the administrative officer should honor the acts done by the previous administration. And then so an inquiry be conducted, the extent of what has gone on, a report be submitted. A report was submitted. Then what happened? The government has decided to cancel the allotment, the grant given to the petitioner's father. That is the brief fact of the case. So aggrieved by that, the petitioner has approached his honorable court by way of the last, the most recent petition. The first one. Now the first, that is WBC 58, Your Lordship. This one is with regard to order passed by the Tobashi's court. The petitioner has challenged an order passed by the Now, in this case, one union called the Monian Union of Gizit. They claimed a portion of the land as having been allotted by the administration. And based on that, and the petitioner had earlier given permission to some other person, to a missionary, to construct a dwelling there, the Monian Union came in and disturbed the possession of the missionary. Then this Monian Union approached the DB's court based on the administrative allotment to the union. The Tobashi's court passed an adverse order against the petitioner. So the petitioner has approached the honorable court challenging that. And now there is a stay order in this matter. While the stay order was still in operation, the Monian Union started making constructions over here, concrete construction. So the condemned petition was filed. So Your Lordship, I'll take Your Lordship to all the facts. In all the three petitions are more or less same, but the impugned orders are different, Your Lordship. So Your Lordship may kindly go to Annexure A, Your Lordship.
Annexure A?
A of the petition.
Contempt petition.
No, the writ petition, Your Lordship. Because
petition number 58?
58 of 2017.
Page number?
Page is 15, starting from page 15. So this is with regard to establishment of the digit circle, Your Lordship.
Annexure A,
Annexure A, yes, your lordship.
it is a representation.
No, at that point of time, it is signed by the ADC MON, and then it is involving chairmans, vice chairmans, and arms of villages of the area. So this talks about the establishment of an administrative circle called the disease circle, your lordship. Here, the first signatory is the petitioner's father, your lordship. So we, the undersigned aunts, GBs, and heads of disease circle, desire and agree to change the name of the circle to disease circle from today and thereafter to hereby willingly consent to locate the circle HQ in a suitable place in disease area with no further objection from any source on this regard should be entertained. Necessary land required for the HQ will be given without any objection. So this was based on this land was given by the various the surrounding villages, arms of the villages. Now, Annexure B, this is 15 November 1968.
Okay, I will come back after 5 minutes.
Sure.
We'll continue.
No, no, no news, sir. He is not coming into the, these are somebody who is not a matter of, yeah, I put, maybe the approach you have.
Yes.
Yes, Your Lordship, I'll take your lordship to the annexure B1. This is the permit.
Annexer?
Annexure B1, page 17. This is the official permit issued by the then administrative authority in 1971 in favor of the petitioner's client. If I may read, Your Lordship. Annexure B1, page 17, page 1.
Come nearer to this microphone.
Yes, Your Lordship. So, Office of the Additional Deputy Commissioner Mon, Subdivision Mon. Special permit for farm land at Dizit, dated the 27th March 1971. 3L Wangshu Konyak RCM is allowed to continue cultivation of the low-lying area, which has already put under paddy cultivation at Dizit. The line of demarcation will follow as follows. 1. A straight line will be drawn from a point on Sonali Mon Road, as shown in the survey map, till it joins another survey mark near the private track, as shown in the survey map. From the survey mark point, it will run straight south till the line reaches the first line of banana trees, after which it will turn straight northwest till it comes parallel to the point marked on the stone by so and so of 24,571. Taking the last point of northwest line, a straight line should be drawn towards south, crossing the marked stone till it reaches another mark on a dead tree. From this dead tree, a line will continue straight for a few yards, turn southeast and join the now Chum area. Following the area firmly joined this year, a line should join at Dizit River near the pool called Chizak. Besides this area, he is also allowed to continue paddy cultivation at the confluence of Dizit and so river, been shown in the map. Besides these two areas, he should vacate all the area he has put under cultivation immediately. The EAC Mon, who is with me, is requested to go down and put boundary pillars with the help of Sri Wangchu and his laborer. So this was it's very difficult without the map, but the map has been later on furnished. So I'll take a lordship to it. But this is the permit which was given in 1971 in favor of the petitioner's father. Now, in 1974, the petitioner's father expired, Your Lordship. Then after that, the petitioner was still a minor at that point of time. Now encroachers started encroaching into the land. So here, page 16, Your Lordship, annexure B. This is issued by the Circle Officer Dizit in 1975. It's a memorandum, Your Lordship. Whereas complaint has been received from GBs and ANGs as well as public of Yanyu village that Sri Nokzam Konyak, Chief Ang of Chapoka village, and Sri Tingpong Konyak TB attached to the Circle Officer's office, Dizit have encroached the land allotted to late Wangshu Konyak at Dizit headquarters, and now holding by his eldest son, Sri Nokman Konyak, White the then Additional Deputy Commissioner Mon, Special Permit Memo number 8487/90, dated the 29 March 1971, under the signature of Sri DCK Lota IAS, the then ADC Mon. I have personally verified the sources as shown in the said permit with the help of Sri Owang Konyak TV and Sri Achoak Konyak TV in presence of the said holder and the GBs and ANGs and public of Yanao village on 11 April 1975, and found bamboo groves, banana trees, stump of a dead tree, papaya trees grown prominently in the said boundary line. Therefore, I do not find any reason as to how Sri Nokzam Konyak and Sri Tingpong Konyak can claim the land by encroachment. I therefore uphold the special permit issued by the erstwhile Additional Deputy Commissioner Mon and further allowed Sri Lokman Konyak, son of late Wangshu Konyak, to cultivate the whole plot of land as allotted to his father under the present care of Sri Danai Konyak, who is closely related to late Wangshu Konyak and resides at visit headquarters since Sri Lokman Konyak is reading in school at Mott. But in no case, Sri Danai K can claim ownership of the land. Also, Sri Lokman Konyak and Sri Tingbong K should stop encroaching the said plot of land immediately in order to avoid further complications. So after the petitioner's father died, encroachments were being made every now and then. So this is one order passed by the then circle officer confirming the earlier permit which was issued by the then ADC Mon. Now, Your Lordship, still after this, encroachments were being continued and even the department, without informing the petitioners, started constructing their own office buildings on the land itself, and at the same time started allotting lands to private individuals. So what happened? The petitioner submitted a representation before the chief secretary, and the chief secretary, after considering the petitioner's representation, has issued this memo, which is dated 18 July 96. That is Annexure C, Your Lordship, page 18. Page 18. If I may read, this is 18th of July 96. A representation has been submitted to me by L. Lokman Wangshu, son of late Loktan Wangshu, alleging that illegal encroachments have taken place in the land given to his father, which he has inherited. This special permit for farmland at Dizit was given to late Loktan Wangshu, the then RCM, and the area given to him was properly delineated. In course of time, encroachments had taken place by police department, industry department, and also by private individuals through permits given by administration at different times. The land given to late Loktan Wangshu, the then RCM, was in recognition for the assistance he had rendered to the administration and also for standing for the people in times of difficulty. In fact, without his consent or his successor, no land should have been allotted to any person or government departments. It appears that no respect was shown to permit holder who was given the farm land by administration in recognition of his services given to the government and the people. Even the Angs of Dizit area had consented to this, as the land falls within their jurisdiction. The administration should always honor the commitment given by previous administration to keep its image in the eye of the people, instead of protecting the privileges given to certain distinguished persons. If the administration allows encroachment by individuals or government departments, it does not show any good image before the public. You are hereby asked to conduct special inquiry and submit detailed report comments as early as possible. So this is addressed to the Deputy Commissioner Mon by the Chief Secretary to conduct an inquiry as to the extent of the allotments and all those encroachments, and to submit a report before him. Now, what happened? Even after this direction was given, as the TC continued sitting over the matter, the petitioner was compelled to approach this honorable court by way of a writ petition, which is WPC 204 of 2012. And Annexure D, page 20, the petition was disposed of by order dated judgment and order dated 5/8/2014 by Justice N. Chaudhary, late N. Chaudhary. Now, Your Lordship, I'll take Your Lordship to the relevant portion of this order, page 22, Your Lordship, paragraph 5. Paragraph 5, page 22. The grievance of the writ petitioner in this case is simple. The land in question was gifted to his father on 29/3/1971. Thereafter, in the year 1975, The circle officer prepared a memorandum on 11/4/1975, recognizing the same. If there is any encroachment, definitely, this is prejudicial to his legal and constitutional right. The Chief Secretary of the State, being aware of the situation, issued direction to the jurisdictional deputy commissioner way back on 18/7/1996 for holding special inquiry. There is no reason as to why the deputy commissioner would not hold a special inquiry as directed by the Chief Secretary. Although detailed report after such inquiry was supposed to have been submitted before the Chief Secretary as early as possible. But the proceeding went hibernating without any valid reason, depicting irresponsibility on the part of the district administration in the process. A proceeding before the Chief Administrator of the state has been stopped. Failure on the part of an authority in complying with direction of his superior not only betrays inefficiency of the administrative machinery of the state, but has also potential of sending wrong signal to the society as to the rule of law, which is so sacrosanct in a democratic setup of governance. Although an affidavit in opposition has been filed on behalf of official respondents, the claim of the writ petitioner has not been disputed. The fact as to issuance of direction by the Chief Secretary is also not in dispute. This being the position, I feel inclined to allow this writ petition and direct the Deputy Commissioner Mon to hold special inquiry as was directed by the Chief Secretary to order dated 18/7/1996. Within a period of 3 months from the date of receipt of certified copy of this order without fail and forward the same to the Chief Secretary for passing necessary orders. The Chief Secretary shall pass necessary final orders within 2 months thereafter from the date of receipt of inquiry report from the Deputy Commissioner Mon. The petitioner shall forward furnish a copy of this order to the Deputy Commissioner Mon and shall get necessary acknowledgement on the body of the forwarding letter. So this was the direction given to the Deputy Commissioner to conduct the inquiry and to submit a report in terms of the direction of the Chief Secretary. Now, I'll take your lordship to annexure E1, page 25. This is the letter of the Deputy Commissioner submitting a special inquiry report. This is dated 31st October 2014. On the subject indicated above, I have the honor to inform you that a special inquiry committee set up to inquire the land dispute at Digit is ready with the final report. The same is submitted to you for your perusal and further necessary action. This was written by the additional Deputy Commissioner to the Deputy Commissioner. And special inquiry report, if I may read, your lordship.
Not necessary, not necessary. So what is your pair in this petition?
In this petition, what happens is that while these things are going on, the Monian Union, claiming that they have an allotment from the administration encroach upon the land. And then on that plot of land, a building, a temporary structure was there, a residential structure, but not a concrete one, attached building. So they decided to drive the person out, who is a missionary, to whom the petitioner had allotted that plot for constructing a building. When this happened, the petitioner objected. Now this Monian Union approached the Tobashi's court. Now the Tobashi's court passed an order. This is the order is the imbued order is annexure G, your lordship, G at page 40. This was filed by a colleague of mine earlier, Your Lordship. So summons was issued to the person to whom the petitioner had allotted the plot. The summon, which is also impugned hearing, that is 10th April 2017, Your Lordship. Annexure G1 and Annexure G, Your Lordship, page 39. So a summon was issued to the person by the to whom the petitioner had allotted the plot. Now, to present himself before the court. And then by the next page, order dated 13th April 2017. Order with reference to a complaint letter dated 23/3/2017 received from Monian Union Tizit Town against Mr. Wangdun Konyak of Nidong Village for construction of house at the allotted site of Monian Union Tizit Town. In this connection, the TB's court Tizit summoned both parties to appear before the TB's court along with site permits on 13th April 2017. The Monian Union Tizit Town produced site permit white number so and so, whereas Mr. Wangdun Konyak could not produce a site permit. Therefore, the TB's court is to hereby directed to Mr. Wangdun Konyak of Nidong Village to vacate the house and remove the materials from the said site, land on or before 13 May 2017. That is within 1 month from the date of issue of this order. So So the land, Your Lordship, my case here in this particular case is that since the land is in possession of the petitioner and then validly allotted by way of a special permit, the district administration had no authority to allot the land to the respondent, that is the Monian Union, respondent number no, the respondent number 5 by way of a subsequent implement proceeding, the implement was done, so it should be respondent number 6, Your Lordship. So the so-called allotment to the Monian Union by the district administration is void ab initio. That is my only case, Your Lordship. So the so-called the order passed by the Subhash's court is undeniable in law, Lordship. So it ought to be questioned, set aside. That is my
Gauhati's
case.
That order is at page number?
Page 40, the order.
40,
Page
the
40.
last one.
Yes, the last one, order.
Yes.
This is without jurisdiction. And without any legal basis.
So you have completed this.
So far as the first that 58 is concerned, Your Lordship. The simple case is that land, it is mine by way of a permit given by the administration. Now the administration cannot take it away from me without my knowledge. It is, and any allotment which is issued is void ab initio. So any order passed favoring the in favor of the allotment issued by the administration is also illegal and must be questioned, set aside.
So you have completed this 58.
Yes, 58. That
Yes,
is-
for
yes.
the respondent.
The counsel for the private respondent is absent without any notice to this honorable court.
That's
Respondent number 6, the counsel for respondent number 6.
Lordship, I'm for the state respondent.
Hmm.
As far as this writ petition 58K of 2017 and the other writ petition that is 207K of 2016. Your Lordship, did any decision that is taken in the writ petition 88 of 2022 will cover up these two matters? For the fact that your Lordship, the petitioner in the other two writ petition, that is 56, 58K and 207K of 2016. They are here before this court impugning the order. There is a restraining order as well as the allotment order given by the government to the private respondent on the ground that the petitioner is a landowner to the plot of land that we have allotted the plot to the private respondent number 6. Whereas in WPC 88K of 2022, they have impugned an order whereby the allotment given to them has already been cancelled. And the government have decided to take back the land that was allotted to them. So if 88K of 2022 is decided, your Lordship, then these two writ petition, that is 58 and 207K, this will automatically be covered, your Lordship.
So he has argued only on this 58.
Lordship.
Yes.
Yes.
I'll take a Lordship too, because since the fact the foundation is same in all the cases, Your Lordship, but then subsequent developments in the next case, that is WPC 207. 207, there being no order of this honorable court, the district administration has directed some of the allottees who are holding land over there to issue restraining orders against them. So I am challenging those restraining orders passed by the administration as without jurisdiction and without any powers, Your Lordship. Because they have no right over the land, which has already been, which is already there with me, which is in my possession, which has been validly granted by way of the special permit in favor of my father, and I have inherited it. So the administration cannot arbitrarily direct individuals to whom I have allotted land to not to do things over there or to vacate the land. But what happened was the district administration has issued these arbitrary orders, which it has no right or power to issue, Your Lordship.
Hmm.
Page 35, Your Lordship, starting from page 35.
Sir, would it be proper to continue with the argument in absence of the counsel for the private respondent?
That is one problem, yes, Your Lordship. With regard to the,
So let us do one thing, we will fix it on next Monday as part heard.
Your Lordship,
Lordship, next Monday, I think it's a holiday, Your
Oh,
Lordship.
yes, then Tuesday,
Lordship, I have some difficulties, Your Lordship.
Tuesday,
Yes, on next week, Your Lordship, I have some difficulties.
then. So
Thurs-
let's set it then,
Thursday, Your Lordship, or to
Thursday.
Thursday, this week.
Even otherwise, Your Lordship, as I was saying, if 88 is decided, because 88, there is no private respondent involved, Your Lordship.
In 88,
88, no.
yes. But
If-
even
if-
then, to dispose of the writ petition number 58,
Yes.
we have to hear the
Yes.
private respondent also.
Lordship, Lordship, actually the petitioner is challenging the action of the state respondent,
Hmm.
not the action of the private respondent. Even in the, it is 58 K, Your Lordship.
Hmm.
So if 88K proves that the land belongs to the state government, then we have got every right, Your Lordship.
Hmm. Hmm.
No, Your Lordship, the fact is, the state has cancelled the allotment, special permit given to the petitioner. Only from that point of time, now, if at all, it is valid, but it is not valid. The state cannot arbitrarily just take away land which has already been granted.
Whether notice was issued to the petitioner?
No notice, only some discussions went on, and then on the basis of the report, the chief secretary also has clearly written.
No,
Submit a report.
whether the petitioner was heard by the authority.
Discussions went on. The authority was asking him to allow the government to do certain things, but he refused. He said, no, you cannot do that. So at least I should be compensated for all those earlier endorsements that have been taken place. And then you cannot just do whatever you want on the land, which is there, which has been validly allotted to me. This is my only source of living now. Now what happened? The chief secretary arbitrarily, after all those reports were submitted before the chief secretary arbitrarily cancelled the permit. It cannot be done in that manner, Your Lord. Just take away the livelihood. When it comes to the state government, if a land is donated to the state government will say, now it is, you don't have any right over it. You have already given it to us, even though no compensation has been paid. But whereas in the case of land which was allotted to the petitioner's father because of his services to the state government, they just take it away whenever they want. That cannot be done, Your Lord. Now, I have, and my family have acquired a right over that land by way of that special permit. It cannot be arbitrarily taken away. So it's unconstitutional. It is a violation of my fundamental rights. So that very order is of cancelling. And even in all these reports are based on the letter issued by the chief secretary in 2006, directing that these kind of things going on, the administrative authorities doing things which is not permissible is not good. So conduct an inquiry as to the extent of the encroachment and all those things and submit a report. That was the only thing which was given. The chief secretary letter nowhere says that conduct an inquiry and then cancel the permit. No, the chief secretary has clearly written that it is not proper for the administration to do these kind of things when land has been specially granted to the petitioner. So the question of cancelling the allotment, the permit given to the petitioner does not arise here. And even this honorable court in the order passing the writ petition has also clearly said, made observation that it is a fundamental right. It is being violated arbitrarily by the administration. The only issue involved in that inquiry should be the extent of encroachments that has been made, the extent of encroachments made by the administration or the permits passed by the administration, and what to do about it. That should be the only consideration. Either vacate or pay the petitioner compensation. That is the only consideration which ought to have been undertaken by the chief secretary now, by the government. But what happened without going into all those things? Just cancel the permit. It's arbitrary. The level of arbitrariness is like a dictatorship. It cannot be done. That is my only case before this honorable court.
In both the petition?
In the last petition, because that is the
88.
Yes. Yes, 88, 2022. In these other two petitions, these are prior to the passing of the order cancelling the permit. And these orders were, your lordship will see it, even on the face of the record itself, it is unsustainable.
Okay.
Yes, there is no order of this honorable court directing that state respondents to restrain development of the petitioner's land, but the state. But since the private respondent in the counsel for the private respondent is absent today, if your lordship deems that it should, and it is also necessary that they should also be heard, your lordship. So, if it may be taken up on Thursday, your lordship. Thursday or Friday?
Thursday or Friday?
Yes, your lordship.
Friday then?
Friday.
Lordship.
Thursday, your lordship.
Thursday?
Thursday.
Heard, Minister? Your good name, please?
Tongpok Pongener.
Learned counsel for the petitioner. And also heard Mr.
And Angami, your lordship.
Learned.
Senior government advocate.
Senior government advocate for the state respondent. Heard in part, lays the matter on Thursday as part third.
Item number 30.
So the total amount of award was 8,87,500.
It like is lordship.
And this annexer A is the impugned judgment.
Lordship. Page 12.
So what are the grounds?
Lordship, we come to page 5. Page 5 of my appeal, lordship.
Yes.
Lordship, ground B.
Hmm.
Maybe without Lordship. For that, the learned tribunal has primarily committed error and illegality in passing the final award without taking into consideration the basic requirements of Motor Vehicles Act 1988 as prescribed under Section 166 MV Act pertaining to the fault liability. Lordship, on that, I am relying on the judgment. Yeah, I got 2007.
You have furnished the copy to?
Lordship, I have given the list of books. Yeah, I got 2007. SCC 1609.
Can you furnish this Xerox copy of this judgment, because we are outstation judge, we have to go back there. We cannot
Lordship.
carry the books with us.
Lordship, I will provide Lordship.
Yes.
Lordship. Lordship, 11 para is grade 9. Para 9, Lordship. Lordship,
Yes.
if Lordship comment on it.
Yes.
Before we proceed to consider the main aspect arising for decision in this appeal, we would like to make certain general observations. It may be true that the Motor Vehicle Act, insofar as it relates to claims of compensation arising out of accidents, is a beneficent piece of legislation. It may also be true that, subject to the rules made in the behalf, the tribunal may follow a summary procedure in dealing with a claim. That does not mean that the tribunal approached with a claim for compensation under the Act should ignore all basic principles of law in determining the claim for compensation. Ordinarily, a contract of insurance is a contract of indemnity. When a car belongs to an owner is insured with the insurance company and being driven by the driver employed by the insured, when it meets with an accident, the primary liability under law for payment of compensation is that of the driver. Once the driver is liable, the owner of the vehicle becomes vicariously liable for repayment of compensation. It is this vicarious liability of the owner that is indemnified by the insurance company. The third party for whose benefit the insurance is taken is therefore entitled to show, when he moves under Section 166 of the Motor Vehicle Act, that the driver was negligent in driving the vehicle resulting in the accident, that the owner was vicariously liable, and that the insurance company was bound to indemnify the owner and consequently satisfy the award made. Therefore, under general principles, one would expect the driver to be implemented before an adjudication in claim under Section 160 of the Act as to whether a claim before the tribunal is entitled to compensation for an accident that has occurred due to alleged negligence of the driver. Why should not the tribunal insist on the driver of the vehicle being implemented when a claim is being filed? As we have noticed the relevant provisions of the Act, we are not intending to just that some principles of law relating to the claim for compensation, which is still based on a tortious liability. The tribunal ought to have in case hand direct the claimant to implicate so and so who was allegedly driving the vehicle at the time of the accident. Lordship. So, Lordship, here she is that the claimant should prove negligence of the driver. Lordship. I mean, we'll have to continue, Lordship. Here, there was also controversy whether it was Muhammad Hussein who was driven the vehicle.
Next,
And
next ground number D.
B, Lordship. B.
No. After B, you have not completed B.
No, Lord. So in that view, I will also like to place one more judgment, Lordship. 2017 to TAC 281. Calcutta. Here the relevant paragraph is paragraph 17. 18, 22, and 24. I mean, we're allowed to read, Lordship.
Paragraph number
17.
17.
17, Lordship.
Yes.
I mean, we're allowed to read, Lordship. The present application filed by the claimant is one under section 166 of the Motor Vehicle Act, 1988. The basis of a claim under section 166 is the rash and negligent driving of the driver. Without the element of rash and negligent driving, no one can maintain a claim under the said section except under no fault liability. There is a fault liability claim, and therefore the claimant has to prove that there has been negligence on the part of the driver concerned. In this context, provision of section 166 is required to be set out in the set below. Application for compensation. An application for compensation arising out of
No, it is not
Lordship,
necessary
not
because it is in the
So-
act itself.
Lordship, we come to section paragraph 18.
18, yes.
Section 166 says that an application for compensation arising out of an accident or the nature specified in subsection 1 of the section 165 may be made. Therefore, provision of section 125 are also required to be taken into consideration, Lordship. Paragraph 19, subsection 1 says that tribunals are constituted for adjudication, claim for compensation in respect of accident involving death or of bodily injury for person arising out of use of motor vehicles or damages to any property, the third party or raising or both. 20. Therefore, on a conjoined reading of section 166 and subsection 1 of section 165 is necessitated that for maintaining a claim application, there has to be some bodily injury to use of motor vehicle. In the second case, the appellant has claimed that because of the rash and negligent driving of the offending minibus, the victim sustained injury and ultimately caused death. Page paragraph 22. Where claim is made under section 166 of the Motor Vehicles Act 1988, onus of proof lies on the claimant. Cogent and reliable evidence in support of contention may be put forward. Claimant cannot proceed as per summaries of general knowledge, particularly in case where compensation is to be awarded. The finding is at page 24, paragraph 24. On consideration of the materials on record, we do not find any illegality committed by the learned claims tribunal in refusing to grant compensation in favor of the claimant. Therefore, we affirm the impugned verdict. Lordship, here the claimant has to prove the negligence as per 166.
That is the elementary principle.
If my next ground is that D. For that, the learned tribunal has been taken into consideration that the claimant has not exhibited any cogent proof of income to prove the income of his deceased father. Instead, made exorbitant income of his deceased father. Rather, therefore, the income as claimed by the claimant remains disproved. Lordship, the claimant is in this claim petition, it's taken the income as 25,000 per month.
2,000?
25,000.
25,000.
25,000.
25,000.
But Lordship, the court below is reduce it to 12,500. Lordship, even otherwise also, since the claimant has not submitted any document to prove the
the member has fixed the
member that's fixed at 12,500. That is also on the higher level.
No, the court below has fixed a notional income in the judgment.
Judgment is at the page 16, relevant portion of the page 15 and 16. Page 15, last paragraph, Lordship. Issue number 3, whether the claimants are entitled to any compensation, it said if yes, what amount in paper by claim. All issues settled the affirmative, and I have held the claimants are entitled to the following compensation. The deceased died at the age of 62 years and 11 months, place approved by Honorable Court 7. The unrebutted evidence of the claimants had said that deceased father was a sole earning member who used to earn 5,000 per month by selling fish and other agricultural products. It is further stated that this father was owner and holding of a agricultural land measuring up to 20 bighas whereupon his father was maintaining a big fishery pond measuring 5 bighas. Same statement also corroborated by PW in her examination in chief, as well as her cross-examination by the opposite party. Even in the cross-examination, the PW want to affirm that the deceased was earning 5,000 per month by selling of fish and other agricultural products producing from own agricultural farming as well as from his own fishery pond. The unrebutted evidence of PW 1-2 without any ambiguity is proof that the deceased was earning 25,000 per month. However, considering the fluctuation of income in the fishery business and also seasonal cultivation, I highly proper to be at 12,500 per month, which is considered as settlement of the taxation. The learned tribunal law is assessed, even though the claimant has a claim for 25,000, as I said, it has 12,000. Even otherwise, his lordship, without a cogent proof of document and
you have not disputed the income.
Lordship.
So it is stated that unrebutted evidence.
Lordship. That is. Lordship in my no, Lordship. Lordship, my W is also not
dispute.
Any comment, any dispute on that. The Lordship, since the claimant has not submitted any document, Lordship, the learned trial below, the new tribunal below has taking the income at 12,500 is exorbitant, Lordship. Lordship, next ground would be F, Lordship. For that, the tribunal urged that 1/4 is the respondent claimant number 1 is a major, and who is 35 years of age as per affidavit in the claim petition, and 836 as per FIR enclosed in the claim petition. Lordship, in this regard, Lordship, you allowed to rely on the judgment of Sterla Verma.
Yes.
2009-6 SEC 121. 2009-6 SEC 121. Relevant
paragraph?
30, Lordship. Relevant paragraph 30, Lordship.
38.
30. 30. My apologies. 30. Lordship, got it out. Read it out, Lordship.
Yes.
Though in some cases the deduction to be made towards personal and living expenses is calculated on the basis of unit indicated in Trilok Chandra, the general principle is to apply standardized deductions, having considered several consequent decisions of this court. We're of the view that where the deceased was married, the deduction towards personal and living expenses of the deceased will be 1/3, where the number of dependent family members is 2 to 3, 1/4, where the member of dependent family is 4 to 6, and 1/5, where the member of dependent family exists 6. Lordship, here the payment.
Whether the deceased was married here?
Lordship, my apologies.
The deceased was married here?
Lordship, And the claimant is a son, along with the wife.
No. How many family members he had?
Lordship, as per the claim petition, there are four.
Four.
Five, Lordship. My please, five.
Five.
Five, Lordship.
Then what would be the amount?
1/4. 1/4.
4 to 5, 1/5. If the family members are five, dependent family members.
Yes, Lordship, 1/4 word members of family member. Dependent family member is 4 to 6. Lordship, in this case, then the learned tribunal is. Lordship, I'm dropping this. I'm dropping this ground, Lordship.
You're dropping this.
Yes. Lordship, my next ground would be at page 7, ground H. Page 7 of my appeal, ground 8, H.
Multiplier.
Multiplier, Lordship. Lordship, here, that is the form 54. Lordship, may.
Age of the deceased was?
The claim.
What was the age of the deceased?
The age of the deceased is 69, Lordship.
60?
69.
69.
But the member motor accident claim tribunal below has calculated 62. So the multiplier should have been 7 and not 5, Lordship. Oh, Lordship, no, should be 5 and not 7.
69 multipliers, so will be this 5.
5, Lordship.
5.
5. Multiplier should be 5, Lordship.
Then the
so Lordship.
Court below has taken 7.
Lordship.
No.
7, Lordship.
No. The court below has assessed the age of the deceased as 62.
62.
If it is 62, then it is 7.
Lordship, but Lordship may come to page 27 of my appeal.
27.
Lordship. Lordship.
Yes. This is the
form
54.
Accident information report.
Yes.
Lordship may come to column 2. Name and full address of injured / deceased person. So this is the deceased that I'm of accident was
69.
69, Lordship.
So whether death certificate was produced before the court? Exhibited?
Lordship.
As exhibit?
That certificate is at the page 38.
38.
Exhibit is a P11.
What is the age mentioned here?
That certificate, Lordship, there is no, his date of birth is not mentioned.
Acha. Then how can the court below has arrived at the finding that his age was 62 years?
That is as per the claim petition. In the claim petition, there is a page 20.
But in the claim petition, his age is mentioned as 69.
Claim petition, he has mentioned is 62.
62.
62. That is a
No, this form 54, it is mentioned as
69.
69.
So that is during the time of accident. This is prepared by the police station.
Form 54 is that page number?
27.
27.
as per Sarla Brahma, the multiplier should be 5. Since that this is a
You have enclosed the claim petition here,
Lordship, it's at page 20,
page
the
20.
relevant page 20,
What's 62 years?
62, Lordship. Even though they have made the claim, the claim petition, the documents show that the deceased, in the instant case, the instant claim petition is he's a 69, Lordship. Lordship can continue after the break, Lordship.
Yes, after break.
Like not strike off. If I strike off, but the problem is he cannot avoid the lower body. Exactly. That is not. Yes, that is. That is. So, we saw the इतना ग्राउंड से प्रेजेंटेशन लगाया था और हेड लगाया था keyboard. They use it. 12%. Oh, 9%.
ঠিক আছে কিন্তু বই দাদা কিন্তু আমি যাই ঠিক বই দাদা কিন্তু সেই ওকে আমি করা Ready?
Yes.
Your Lordship, we were on the page 7. H. Close H. On the H of the deceased.
Yes. So as per Form 67 or Form 54, it was 69.
69. Lord.
And as per this
Claim petition.
claim petition, it is 62. So what is your submission on this point?
Lordship, that the claimant can put any age, but the document shows that the deceased is 69 years. So the tribunal below has erred in calculating the multiplier 7.
So according to you, this Form 54 has to be relied upon.
Yes, Lord. And multiplier should be put as 5. And Lordship, 2 more grounds I'm going to rely, Lordship. Ground I, page 7, ground I. For that, the learned tribunal is erred in law by awarding under the head of pain and suffering an amount of rupees 30,000. As the deceased died after a few hours, like is not tenable in the eye of law. As loss of estate, loss of contingent, and funeral expenses have been awarded as per law, and as such, the same is liable to question set aside. Lordship may come to the impugned order at page 16, Lordship. Page 16 of my appeal. Lordship, here, your learned tribunal has the column, Lordship. Pain and suffering as deceased died after a few hours of accident. That is not a head, Lordship, as per Prenashiti.
As per?
Prenashiti.
Prenashiti.
That is 2017, 16 SSC 680.
Yes.
In Prenashiti, Lordship, the Apex Court has laid down 3 heads in case of death. That we'll find out that paragraph 59.8. 59.8. Reasonable figures on conventional heads, namely loss of estate, loss of concerted and funeral expenses should be 15,000, 40,000, and 15,000 respectively. And but Lordship. So, but in the instant case, the Learned Tribunal has awarded another head, that is the serial number 2. Pain and suffering as the deceased
Pain and
died.
suffering usually it is accounted in the case of
Lordship,
injury
pain and
cases.
suffering, Lordship, exactly, Lordship. So in the case of that, these are the only heads. So this should be deducted. In fact, this should be deleted. And Lordship, finally, K. There is a page 8.
Yes.
Okay, I mean, you'll have to read, Lordship. What is the learned member? Motor accident claim tribal motion?
9%.
9%, Lordship. Here the
No, but this is settled by Supreme Court in several other cases. 9% is the
Lordship, that I leave it to you, Lordship, but that submission, Lordship. As per Sarla Verma, it's,
no, after Sarla Verma, in several judgments, Supreme Court has awarded this 9% per annum.
Lordship. Lordship,
So,
off the record, but in fact, Lordship, the Apex Court in some cases have awarded them 12%.
pardon?
Off the record, Lordship. The Apex Court in some claim petitions, in some case, the Apex Court has even awarded 12%. So it's for the
12%.
12% also. But my submission is based on the Salarama. So I leave it to you, Lordship.
So according to you, what would be the appropriate percentage?
As per the Salarama, my contention is 6%, Lordship. Right?
6%.
Lordship. That's for my Lord. Obliged.
Yes, Mr. Sharma.
May it please your Lordship. Lordship, I have prepared a gist. May I forward one copy, Lordship?
No, but you might have prepared a gist, but you argue on the point.
Yes, Lordship.
Which Mr.
Certainly, I shall argue in
Ponte
the
has,
Lordship. So before starting my submission, Lordship, I want to submit before your lordship about the fact of the case, lordship. The fact of the case is that the deceased by profession was a self-employed person dealing with selling and purchase of fish and other agricultural product from his own fishery pond and from his own cultivation. At the time of death, the deceased was 62 years and used to earn undisputed amount of rupees 25,000 per month. However, the tribunal considers only 12,500 per month for assessment of compensation. The deceased left behind his widow and 4 children. On 25/8/18, after depositing some money at bank while deceased was returning home and at reaching Gauhati, the offending vehicle number AS 07C4170 suddenly turned to the garage without looking to the pedestrian, knocked down and ran over the deceased with great force. Resultantly, the deceased sustained grievous injuries and was brought to the civil hospital Lakhimpur. However, having seen the grievous injuries, the civil hospital referred the victim to Gauhati for better treatment. However, on the way, the deceased injuries succumbed to his injuries. Lordship, the allegation raised by the appellant in ground number B and G. In ground number B and G, the appellant objection is that there is no rash and negligent driving.
No, he has not not pressed those grounds. He only relied upon this B, D, F, K.
Yeah, ground
F,
number
H,
B and
I.
G. Ground number B and G is concerning with the rash and negligent driving. He has already cited before your lordship.
B he has
Yes,
he has
B
pressed
and
it,
B
but
and
Z
E.
he has not
Z
pressed
also relevant, lordship. Both are identical. B and Z is identical. So my submission against both. Lordship, the evidence of the claimant to be scrutinized before saying that there is no rash and negligent driving. The whatever evidence in the court below, lordship, while in examination of PW1, that is the claimant number 1. In his examination in chief stated that, whereas I am the claimant in the instant case which I have filed on account of death of my father, late Idris Ali, on a vehicular accident dated 23/5/18 due to rash and negligent driving of the driver of the offending vehicle number Suen's Crane. At the time of death, my father was returning from Naoboisha after depositing some money with a purpose to go for Hajj as pilgrim. While my father was returning reaching at Gauhati of North Lakhimpur town in front of Sriram Hotel, the offending vehicle number so-and-so suddenly turned to the garage without looking the pedestrian using the road and knocked down my father with great force. As a result of which, my father sustained grievous injuries and shifted to civil hospital. The injury of my father was so serious, as such, the North Lakhimpur Civil Hospital immediately referred my father to Gauhati. However, on the way, my father succumbed to his injuries. The accident dated 23/5/18 was the sole negligence of the offending crane who killed my father without his fault. That is the examination in chief of the PW1, lordship. Now, what happened in the cross-examination? The PW1 was cross-examined by the OP number 1. In reply to the cross-examination of the OP number 1, the PW1 categorically stated that it is only reaffirmation, lordship. It is correct to say that the accident was caused due to rash and negligent driving of the driver of the offending vehicle number so-and-so. It is correct to say that the accident occurred when my deceased father was returning from Naoboisha after depositing some money with purpose to go for Hajj as pilgrim. I deny the suggestion that the driver of the offending vehicle number so-and-so was not at fault. However, I reaffirm that the accident was due to rash and negligent driving of the driver of the offending vehicle. There is no cross-examination on the point that there was no rash and negligent driving of the driver. And the deposition of the PW1, cross-examination of the PW1 is remain unshaken, lordship. Now, lordship, In examination of PW2, she is the wife of the deceased. In her examination stated that, whereas I am the wife of my late husband Idris Ali, and the present claim petition is filed jointly and severally along with my children on account of death of my husband in a vehicular accident dated 23/5/18 due to rash and negligent driving of the driver of the offending vehicle number so and
No,
so.
Mr. Soma says not the eyewitness to the act.
Lordship, in accident cases, eyewitness is always not available there. Nobody may know, wait there that there will be some accident, I have to see. It is not like that, Lordship.
No, that's all right.
Yes,
But
Lordship.
she is not eyewitness.
Lordship, only point is, in what way cross-examination has been done? Is there any dispute in regards to the rash and negligent driving?
No, though he has taken the ground, he has not seriously disputed those facts.
Lordship. So, then my summing up is, Lordship, from the available evidence in record, rash and negligent driving of the offending vehicle is well established. The respondent claimant respectfully submit that MSC claim is a summary in nature, summary in civil proceeding when the claimant is not required to probe the case as if like other civil and criminal cases. For satisfaction of this honorable court, the claimant respondent referred the following decision for your lordship. These decisions are already, even yesterday also in 2 cases I have already cited before your lordship. So may I repeat it, lordship?
Not necessary.
Lordship. Now, lordship, the ground number D, the allegation is no income proof. Now, lordship, there is no dispute at all in regards to the 25,000 monthly income of the deceased, lordship. Lordship, in examination in chief of the PW1, stated that at the time of death, my father was 62 years old and a good health and physique. He was sole earning member of our family and used to earn net profit of rupees 25,000 per month by selling of fish and agricultural product. My father was maintaining a big fishery pond measuring 5 bigha of land, also having 20 bigha of agricultural land, whereupon we are jointly cultivating and producing various fishes in the fishery. To reply the cross-examination of the opposite party number 1, the PW1 stated that it is correct to say that my father was the sole earning member of our family and used to earn rupees 25,000 per month by selling fish and other agricultural products. It is only reaffirmation, lordship. There is no dispute at all in regards to the income of my father, lordship. Lordship, in examination of PW2, Lordship, in examination of PW2 stated that at the time of death, my husband was 62 years old with a good health and physique. He was sole earning member of our family and used to earn net profit of 25,000 per month by selling of fish and other agricultural product. My husband was maintaining a big fishery pond measuring 5 bigha of land, also having 20 bigha of agricultural land, whereupon we are jointly cultivating and producing various fishes in the fishery. To reply the cross-examination, the PW2 stated that it is correct to say that my husband was earning net profit of rupees 25,000 while he was alive and whereby managing our family. It is correct to say that my husband was a businessman dealing with selling of fish and other agricultural products. Lordship, the unrebutable evidence of the claimant made it clear that at the time of death, the deceased used to earn 25,000 rupees per month. However, the tribunal, by ignoring such vital evidence, considered only rupees 12,500 for assessment of compensation. The deceased was a self-employed person and working in an unorganized field. There is no employer to issue income certificate. That is why claimant made a moderate self-estimation.
No. If you have big fishery, if you have cultivating land, You can obtain, you could have obtained it from the, the circle officer.
That is only lordship. Circle officer can only give my certificate about my land record, that I have a land.
Yes,
land
he could
so-
have certified that, they, sometimes they used to assess the income also.
Lordship, but only thing is that there is no dispute in the court below.
Okay, that's all right, but.
Yes, lordship. That is different issue. What suggestion given by the lordship, it is true. A circle officer can give the certificate.
Yes.
That
income of
certificate can
the-
be obtained from the circle officer.
Yes.
But there is no dispute as such in the court below, lordship. Lordship. And lordship, the respondent claimant being the wife of the deceased, she know
So,
well about the income.
The court has fixed the notional income.
No, lordship. Court has assessed only 12,500 per month instead of rupees 25,000 per month.
No, that is notional.
Notional income is not like that, lordship. Notional income is now approved by the Supreme Court. Is six-
On what basis the court has assessed it?
Court has assessed from his suo motu. This is a suo motu assessment of the court. Suo motu assessment of the court. Notional income actually, lordship, earlier before in the second schedule, it was only for 15,000 per month. Thereafter, it can be increased to 3,000 per month. And now it is increased to 6,500 per month. And now national income fixed by the Honorable Supreme Court 30,000 per year. So that part is not relevant here, as because the evidence of the claimant, there is no dispute in regards to the income.
No, Mr. Soma, you see, if the witnesses have deposed that income of the deceased was 25,000.
Yes.
Court can abruptly cannot fix the income as 12,500. What basis? What is the basis?
Probably
is the
court
reason?
might have from his own notion.
No, what is the reason? The own notion, that is notional income.
Maybe, lordship.
Is there any formula of fixing the notional income?
There is a guidance of the Honorable Supreme Court only.
Yes.
Regarding notional income.
Yes.
So now, as per.
Now, if according to you, this is the notional income fixed by the learned court below, then.
Lordship, as per judgment, Honorable Supreme Court 2023 1 SCC is 204 held that national income should be adopted as 30,000 per year.
Oh, each and every person of the country.
No, 30,000 only. Yes, those who have no income. Those who have no proven income. In that regard, only 30,000 to be considered as a national income per year. And
Per year?
Per year, lordship. Which to be considered for assessment of compensation, lordship. So here, lordship, the question of national income does not arise because I have a fixed income.
You have already stated that court has on its own notion fixed at 12,500.
That is why court ought to have take 25,000 rupees per month as for assessment of compensation, but court has very niggardly considered only 12,500 as a per month income. Very niggardly. Lordship. Lordship, here in Ketnao cases, lordship, Honorable Supreme Court held that, I am satisfying your lordship, in Janbai, wife of daughter of Dinkarao, Ghorapade versus and others versus ICICI Lombard General Insurance Company, the 2022 para 10 SCC 512, the relevant para 15, wherein Honorable Supreme Court held that the evidence of the appellant number 1 on affidavit is that her husband was getting salary of rupees 12,450 and that he was over 50 years aged. The learned tribunal assessed monthly income of the deceased at 10,000 in absence of proof of salary, which has been approved by the Honorable Supreme Court in terms of the judgment passed in National Insurance Company versus Pranay Sethi, 2017-16 SEC 608. Even when there is no proven income, Honorable Supreme Court has considered 10,000 rupees per month. But in my case, I have a proven income, Lordship. Undisputed income of rupees 25,000 per month.
No, proven and undisputed are two different things.
Yes, Lordship.
Proven means how you proved it, by
Because
adducing
wife is
evidence
the-
or by exhibiting documents.
Lordship, wife
So
is
you
the
have not exhibited a single document in respect of
Lordship,
your income.
Lordship, wife is the best evidence to know what was the income of the husband. Being a villagers, Lordship, how many villagers can use to maintain
No,
bank account there?
That's why the notional income.
Yes, Lordship. Lordship, try to satisfy your Lordship. In Shiv Kumar M versus Managing Director, Bangalore Metropolitan Transport Corporation, 2017 5 SCC 79, para 5 and 6. In para 5, held that no doubt there was no evidence available with regards to the income of the appellant. But there is no dispute on that he was painter by profession. The accident happened in the year 2013 when he was living in Bangalore, Karnataka for a casual worker. He goes from house to house and place to place doing his painting work. It is difficult to get any evidence since there is no employer. He does his daily work, sometimes price-rated work as well. That is why he made a moderate self-assessment estimation of his income of rupees 15,000 to 16,500 per month. Lordship, in para 6 held, in absence of any serious dispute on the part of the respondent on the avocation and income, we are of the view that the tribunal and for the matter, the High Court should have accepted the evidence of the appellant. Therefore, we assess the monthly income as 15,000 and after deducting 1/3 towards his personal expenses, the income will be assessed for the purpose of computation of compensation as rupees 10,000 per month. The income is substituted as 10,000 in place of rupees 6,500 as assessed by the High Court. The compensation will carry interest at the rate of 9% per annum from the day of claim petition. Before the tribunal, raise the award is maintainable, Lordship. Lordship, another decided cases.
Not necessary.
Lordship.
There are a number of cases. At this point.
Lordship, another Supreme Court cases is that Syed Siddiqui versus Divisional Manager United India.
Not necessary.
Lordship.
Not necessary. You come to other point.
Lordship, ground number F, Lordship. That ground number F is abandoned, so I have no submission in this regard. Lordship, in ground number H, allegation is that the age of the deceased should be 69 years as per Form 54. Lordship, Form 54, only the mere information of the police to the tribunal as well as to the claimants and others. That cannot be a conclusive evidence, Lordship. Whatever.
May not be, but
Lordship.
From where the police officer got the information
Maybe
furnished by the family members of the deceased.
Lordship, that is not like that. He may know because at the time of accident, family number was not there. Family members was not in the spot. So whoever
Then
persons
on what
there,
basis it was filled up as 69 years?
that is why, Lordship. That is the Form 54 report.
Usually Form 54 is filled up on the basis of information furnished by the relatives of the victim.
Relatives of the victim may not be from the claimant, Lordship. May not be from the wife also.
May not be.
It may not be, Lordship. But only question is that evidence to be considered herein. What evidence before the court below in regards to the age, Lordship? The wife of the deceased is the best evidence to say that the age of her husband was 62 years. Otherwise, also there was no dispute in the regards to the age of the disease in the court below. To reply the cross-examination of the opposite party number 2, that is the wife of the deceased, stated that it is correct to say that at the time of death, my husband was 62 years old. In the course of proceedings, neither any contradiction in examination in chief nor in the cross-examination in regards to the age of the disease, as such evidence of the claimant throughout consistent. There is nothing any dispute, Lordship, in the court below.
No, that is different aspect.
Lordship. So that is why the evidence of the claimant throughout consistent, Lordship. Regarding ground number I, Lordship, allegation is that
Pain and suffering.
no pain and suffering. Lordship, Honorable Supreme Court, AIR 2023 SC, page number 3333 in para 8, is held that when a person in the last portion of the
No, that's all right. But tell me, what is the strength of that bench?
Lordship. It is a DB, Lordship.
Pardon?
Division bench, Lordship.
Division bench.
Lordship.
So Prannoy Sethi was a 5-judge bench.
5 judge bench.
So the division bench cannot overrule the decision of Prannoy Sethi.
Pain and suffering, no, Lordship. That is different issue. In the Prannoy Sethi case, Honorable larger bench held that is not in regards to the injury cases, Lordship. That was decided only in case of death. For death, the claimants are, along with the other compensation, some conventional compensation are also entitled. Say, for example, for filial consortium fixed by the Honorable Supreme Court as 40,000 rupees. And the spousal consortium also 40,000 rupees. And parental consortium also 40,000 rupees. So these are the findings of the Honorable Supreme Court.
But doctrine of binding precedent, as per doctrine of binding precedent, the 5-judge bench decision cannot be overruled by a 2-judge bench.
No, Lordship, here that in Prannoy Sethi case was decided exclusively with regards to the death case, Lordship.
Here also the person died.
No, here also person died because this person died after few hours of accident while he was under course of treatment. So that is why the compensation in regards to the pain and suffering was awarded, Lordship.
But it has to be seen, how can the court ignore the decision of 5 judgments? Anyway.
Lordship, I maybe cited the last para 8, 2000, AIR 2023, page 3333, the relevant page number 3335, para 8, Lordship. The last portion, Lordship, last portion of the paragraph, having regard to the fact that
para number
8, Lordship, page number 3335. Just before starting of para 9, Lordship, having regard to the fact that the claimant remained in hospital for 10 days and was also in continuous treatment, therefore persuade us to avoid additional compensation towards pain and suffering. Hence, we award additional compensation of rupees 50,000 under the head of pain and suffering, Lordship. So
no, in that case, the person was alive for 10 days. Here, few hours.
So in that case, Lordship, Honorable Supreme Court has awarded 50,000 pain against pain and suffering, but in this case, only 30,000 rupees because the person died after few hours of accident. He suffered loss before that. If a person died immediately, then there is no pain and suffering.
Whether the court has taken into account the decision of Prannoy Sethi in this case? Not discussed,
No, Lordship.
not discussed.
However, Lordship, in Ketnaut cases, Honorable Supreme Court awarded compensation for pain and suffering, Lordship. Even in case of injury, special diet.
No, in case of injury, it is all right.
Yes, Lordship.
It is all right.
Because pain and suffering, the claimants are entitled because the disease died after few hours of accident, and during that period, he suffered loss.
See, okay.
Lordship. Lordship, in ground number K,
Okay, he has not relied upon.
in regards to the interest. Oh,
Sorla Barma. Yes, K. he
K,
has
yes,
relied
it
upon
is there, Lordship.
interest. So it is settled by Supreme
It is
Court,
settled by,
9%.
there is a so many
Nine-
judgment of the larger bands, 9% interest to be granted. Lordship, here, my one more submission before your Lordship. While awarding the compensation, the learned member failed to award parental consortium of rupees 40,000 each against 4 children. That is rupees 1,60,000. The respondent claimant respectfully prayed for awarding the amount, Lordship. Even without filing a cross objection, said amount may be awarded by this honorable court. For satisfaction of this honorable court, the respondent claimant relied upon in Nagappa versus Guru Dayal Singh and others, 2003, 2 SCC. It is a 3-judge bench, Lordship, judgment. The relevant para 7 and 21. Lordship, in para 7, firstly, under the provision of Motor Vehicle Act 1988, hereinafter referred as the MV Act, there is no restriction that compensation could be awarded only up to the amount claimed by the claimant. In an appropriate case, where from the evidence brought on record, if the tribunal court considers that the claimant is entitled to get more compensation than claimed, the tribunal may pass such award. The only embargo is it should be just compensation, that is to say, it should be neither arbitrary, fanciful, nor unjustified from the evidence. This could be clear by reference of the relevant provision of the Motor Vehicle
The
Act.
question is, can the court award it behind the back of the other side?
No,
They have
Lordship.
not to file any petition to.
No,
the
cross
cross
objection,
to
filing of cross objection is not required, Lordship, as per this decision. And there are so many decisions of the Honorable Court, and for filing of cross objection is not required for enhancing the compensation amount by this Honorable Court. Because just compensation to be awarded, so if the compensation is just, not beyond the record, that can be awarded by your Lordship.
Okay.
Next, Lordship.
So these are my humble submission before your Lordship.
Lordship, if the claimant want to enhance either the
No,
income.
let him complete. Yes.
So, Lordship, my humble request is, their prayer is.
Not request submit.
No, sorry, Lordship. My prayer is, my humble prayer is, Lordship. By filing unmerited appeal, the appellant is causing inconvenience to the road victim's family.
No, that's all right, but
As such,
there
this
is
appeal is-
provision for appeal and revision, and they have availed it, where they have.
As such, because of that, when there is no merit of the appeal, their appeal is liable to be dismissed with cost. This is my submission, Lordship.
Yes, Mr.
Next, Lordship. Lordship, if the claimant is disputing on the judgment of the award, particularly on the income, and the the claimant should have filed a counterclaim to either enhance or to stick with the claim petition filed for the court, before the tribunal member. That is a one, and lordship, the counsel for the claimant has rightly stated on the apex court judgment stating that national income should be 30,000 per month in year, sorry. And if coming to the heads of loss and life infection, where the claimant has claimed for 50,000 each. If the claimant, they view that the court below, the tribunal below has erred in passing the award, then they should have approached this zonal court with a counterclaim petition. And with respect to the age, lordship, on the record, the age of the deceased is shown as 69. Just by giving evidence, that will not sustain lordship. In fact, if the claimant, so it has to prove that the deceased, the claimant's deceased father was 62 years. He should have either produced a document, either a ration card, either a voter's ID, either there are many other documents to prove that the deceased was 62 years of age. But in the form 52, it's shown that it's 69. And that information, like Lordship has rightly stated, that information will be get from not from any other person, but from the family members. That's all, my lord.
Heard Mr. F. Fote, learned counsel for the appellant, and also heard Mr. B. N. Sarma, learned counsel for the respondent. Argument concluded, judgment reserved.
Much obliged.
Any other matter?
Yes, sir. For hearing, item number 23.
Mr. Fote, the judgment you have relied upon,
Lordship.
you can give it the Xerox copy.
Lordship, I'll do that, Lordship.
Because it may not be possible that I may pronounce the judgment here.
Lordship.
In that case, I have to carry the file to principal seat.
Lordship.
So these books cannot be carried.
Your Lordship,
Yeah.
I'm for respondent number 5 and 6 in this case.
Yes.
Yes.
In the make appeal.
Pardon?
In the make appeal, there the vehicle owner and the driver.
Which matter?
The
Appeal.
Yes, the appeal.
Such
Make
a-
appeal.
okay. Record her presence. Respondent number 5 and
6.
6. Okay. Yes. So this is criminal appeal.
Yes, Lordship, this is an appeal, Lordship. Lordship, I was convicted under section 376, subsection 2 and clause L. Clause L pertains to committing an offense of rape against a mentally or physically challenged person. I was convicted for a period of 10 years, Lordship, in the year 2019, Lordship.
Whether the state has filed objection? Yeah. Oh, no, not file objection.
Lordship, paper book is already prepared, Lordship. All the records are here in the paper book, Lordship.
So both the parties are ready for hearing?
Yes, Lordship.
Ready. Okay. So what are the grounds?
Lordship, the grounds are, Lordship.
Hmm?
There was no eyewitness, Lordship, in this case. I was convicted solely on the testimony of the prosecutrix, Lordship.
So where is the bar?
Lordship, this case is a very peculiar case.
Why should we disbelieve the version of the victim?
Lordship, in the medical report, the prosecutrix was examined and the medical examiner has clearly stated that she is a mentally retarded person, Lordship. So the question of whether the statement of a mentally retarded person can be admissible, Lordship, and to what extent?
Where is the medical, medical certificate?
Page 66, Lordship.
Of the paper book?
Yes, Lordship. Yes, Lordship. Page 66. There are several infirmities, Lordship.
Okay, we will see. First, you point out the relevant observation made by that.
Relevant observation 67 at the bottom of the page, Lordship. Page 67, remarks of the head of department, if any, at the bottom left, Lordship. If your Lordship got it. Mentally retarded, Lordship. And if your Lordship may kindly come to the top, there is general, Lordship. Under general, the second is mental state, cool, calm, excited, depressed. So it is clearly remarked as appear mentally retarded, Lordship. This is the medical report, Lordship.
As appears mentally retarded.
Yes, Lordship.
But whether she has been examined by any expert to that?
No, Lordship, no, Lordship.
Then
And Lordship knows very
this
well.
finding is relevant here. As appears mentally retarded, but she has not been assessed by any medical expert to that line.
No, Lordship. No assistance was given at the time of examination, Lordship. That is quite surprising, Lordship. I fail to understand how the London Trial Board has come to a conclusion basing on the statement deposed by the victim before the trial court, Lordship. Secondly, Lordship, the FSL report clearly states that there is no content of sperm, Lordship, spermatozoa.
Maybe not necessary.
Yes, Lordship,
Not necessary.
but there are certain
If you
decisions.
go by the definition of the definition of that rep.
Yes, Lordship. And secondly, there are various other grounds, Lordship. Out of those grounds, there was no sign of struggle, there was no injury, Lordship. I'll be very precise and I'll limit my submissions, Lordship, only to the relevant facts as well as the question of law, Lordship.
Your first point is the learned court below relied upon the sole evidence of the victim.
Exactly, Lordship.
Secondly, she is mentally retarded as per evidence of the doctor.
Exactly, Lordship.
And third point is?
There was no sign of struggle. There is no sign of injury as per the medical report of the victim, Lordship. No alarm was raised, Lordship.
No sign of struggle and?
No sign of injury.
Yes.
Medical report also says that the human was torn, but it appears to be all, Lordship. It appears to be all. And she was examined within 2 days from the date of occurrence, Lordship. But the medical...
Did you cross-examine the doctor on that point?
Yes, Lordship.
What does he mean by all?
Lordship, it was not specific with that. No specific query was raised at the time of the... As far as the all is concerned.
How it would help you?
The report is very clear, Lordship. It was exhibited before at the time of trial, Lordship. Lordship also knows very well about the settled principle of law. This is a punishment. The minimum punishment can be imposed 10 years, Lordship. Now, the principle is very clear that the fuller or the higher the gravity of the offense, it has to be the higher the proved. There are certain legal principles that has to be followed in this case, Lordship.
That's all right.
May I take your Lordship to the FIR as well as the charge sheet and the impugned judgment, Lordship?
Yes.
Lordship will find it FIR at page 28. Page 28, Lordship.
No, where is the written complaint?
Lordship will find it page 31. Page 31.
31, yes.
May I read it, Lordship? This is an FIR dated 5th of September 2013.
Who lodged the complaint?
It is an aunt of the victim, Lordship. She is an aunt of the victim, Lordship. May I read it, Lordship? It is a short complaint. With due respect and request, we the family members of so-and-so of Jumikritima town, Ward number 6, we lodged the complaint regarding rape against Miss so-and-so on 5th of September 2013. 5th of September 2013, this date is only important, Lordship. In received, being handed over, the rapist being handed over to your respected police station. Therefore, we request you cooperation and request to take serious action against the culprit. That is the written complaint, Lordship. This was lodged on 5th of September 2013. Lordship will also find the charge sheet at page 35. It is only 2 pages charge sheet, Lordship. May I read it, Lordship? If your Lordship got it, page 35.
Yes.
This is charge sheet dated 4th September 2014. The prosecution of the case is that on 5th of September 13th, a written complaint report was received from one Miss so-and-so of Jumukritima, stating that on 5th September 13th, one person has raped so-and-so at Jumukritima ward number so-and-so, and they apprehended the accused and handed over to the Bupar police station on receipt of the FIR. OC, the Bupar PS registered a case by so-and-so number under section 376 IPC and endorsed to me for investigation, which I took up. In the course of investigation, both the victim and the alleged accused were taken to District Civil Hospital for obtaining legal medical formalities, which the doctor has done. Accordingly, both the accused and the victim were thoroughly interrogated and examined, and the alleged accused was kept at Dipubar police station lockup, and the victim was allowed to go home along with her mother. During the course of investigation, the alleged accused, the victim, the complainant, and the available witnesses were thoroughly interrogated and examined. Statement of the complainant recorded. On being examined, the complainant, her statement corroborated with her FIR. The statement of the victim recorded. On being examined, the victim, namely so-and-so, stated that the incident took place on 3rd of September 2013. This date is very important, Lordship. This is her statement. She also stated that on the day her mother was out from home as usual, she went to bazaar and she was alone at home for a whole day. She also stated that on 3rd of September 2013 at around 6 p.m., this time is also important, Lordship, when she was taking bath outside her house, Mr. So-and-so came near her side and pushed her from behind. So she screamed and called one of her neighbor. She screamed and called one of her neighbor, Lordship, but he could not hear. And after that, she went inside the house thinking that he might have gone. But later, after a few minutes, when she was dressing up inside her room, the accused entered inside her room and raped her. So on the next day, she narrates about the incident to her mother. Further statement of the witness, Mrs. So-and-so, recorded and being thoroughly examined, she stated that on that day, she went to bazaar for selling vegetables, as well as usual as she is a vegetable vendor, leaving a daughter alone at home. She also stated that on the evening, she returned home at around 6:40 p.m. At that time, her daughter, Miss So-and-so, was found sitting in the dark. So she asked her why she is sitting like that. But she did not say anything about the incident. She also stated that the next morning, so-and-so told her that she will not stay alone. She also asked her what happened at that time. She told her that on so-and-so, when she was alone, that person come and rape her. She asked her whether she could identify the man. So she said she know the man and told her that it Mr. So-and-so, their neighbor. The statement of alleged accused recorded. On being interrogated, the alleged accused person, Mr. So-and-so, stated that he is stated that on that particular day, that is 3rd of September 2013, at around 6 p.m., he saw Miss So-and-so taking bath outside the house. So he just go nearby her and pushed her from behind as part of jokes. So Miss So-and-so got angry and got inside the room. So after a few minutes, he entered inside the room to apologize her for his mistake at that time. Miss So-and-so was dressing. So she stated that he just said sorry for his behavior and left for his place, but he did not rape her. That is the statement of the accused. Further exhibit sample of so-and-so swab was sent to FSL Gauhati for obtaining expert opinion. And the same was obtained. The preliminary medical report of District Civil Hospital Dimapur conducted by Dr. So-and-so enclosed. It is to mention that on being properly examined, the victim, Ms. So-and-so, strongly alleged that Mr. So-and-so has raped her, though Mr. So-and-so denied to the allegation against him. However, he admitted that he have pushed her from behind when she was taking bath. On being examined, Ms. So-and-so and her mother, Ms. So-and-so, ascertained that the incident took place on 3rd of September, not on 5th of September, as mentioned in the FIR. Thus, being on the circumstances evidence, it is proved that Mr. So-and-so has committed an offense under Section 376 IPC by raping a woman. Hence, a prima facie case so-and-so is well-founded against so-and-so for committing rape. May I therefore send him to court to face the trial under the above-mentioned section of law. The witnesses mentioned in the so-and-so column number 13 may be kindly summoned by the court after fixing a date for hearing. So this is the content of the charge sheet, Lordship. Altogether, 6 witnesses were examined by the prosecution to bring home the charges leveled against the accused person, Lordship. May I take your Lordship to the deposition before the judgment?
Whether the 164 statement of the victim guard was recorded?
Yes, Lordship, 164.
Where is that statement?
Lordship will find the statement of you will find it page 53 under 164, the statement of victim, Lordship, as well as the accused and the complainant, Lordship. Page 53, may I read it, Lordship? This is the statement of the victim, Lordship. On being examined, the victim, Ms. So-and-so, stated that the incident took place on 3rd September at around 6 p.m. when she was alone at home. She also stated that on the day her mother was out from home as usual, she went to bazaar and she was alone at home for whole day. She also stated that on 3rd of September 13 at around 6 p.m. when she was taking bath outside their house, Mr. So-and-so came nearby her side and pushed her from behind. So she screamed and called one of their neighbor, but he could not hurt. And after that, she went inside the house thinking that he might have gone. But later, after a few minutes, when she was dressing up inside her room, the accused entered inside her room and raped her. She stated that the alleged accused has raped her on the floor of her room. She also stated that her mother returned from home after this incident took place, but that night she did not tell her mother about the incident. And only on the next morning she narrates about the incident to her mother. This is a statement of the victim, Lordship.
So her evidence before the court?
Lordship, her evidence at page 58, Lordship. If Lordship got it?
Yes.
The position of witness so-and-so, aged about so-and-so, taken on oath, age of solemnly affirmed before so-and-so. My name is so-and-so, my father's name is so-and-so, my name is so-and-so Jaluki, I reside at present so-and-so, parent district. Oath administered. My name is so-and-so on 3rd of September 2013 at around 5:30 p.m. Lordship. I was taking bath. This time changes here, Lordship. There's a slight variation. Accused Pompa came and went. After some time, when I was dressing in my bedroom, he came and went, Lordship. Accused came again. He undressed me. I shouted, but no one came to rescue me, and the accused ignored my resistance, committed rape on me. I did not disclose the incident at that very night due to scare, but the next morning I disclosed it to my mother when she was about to leave home, leaving me alone at home. I know accused so-and-so by name and by a face who is now standing in the door. Cross-examination. It is correct to state that I have not reported the incident to my mother as I was scared. Second, I do not know from which side the accused entered the house as the door was kept open. That is the Lordship.
Whatever she has testified in her examination in chief remain unrebutted in cross-examination.
Lordship.
And her statement is consistent with her statement under section, her evidence is consistent with her statement under section 164. What is your case then?
Lordship,
You even never put a suggestion also that he has that the accused has not committed such and such offense. Not a single suggestion is there.
yes, Lordship.
Hmm?
Apparently, that is the record, Lordship. Now, I have to rely on the record, which.
So where is your case then?
Lordship, if your Lordship may kindly allow me to take at the relevant point of time regarding the settled principle of law as far as the statement
That principles
of
are there, but in the present facts and circumstances, the question is whether those settled principle will advance your case.
Lordship, this is a peculiar case in which
Her
the medical expert,
evidence remain unrebutted and she remain firm in cross-examination.
medical expert, Lordship, as far as the opinion of the medical expert, clearly stated that she is a mentally
No,
retarded
maybe
person,
mentally retarded. There may be some degrees of mentally retarded persons. From the evidence she has testified, adduced before the court, from the statement given by her before the magistrate, can it be said that she is a mentally retarded?
No, Lordship, there is another aspect of the matter,
What
Lordship.
aspect?
It
You
is
see,
stated
she has described the date, time, and place of occurrence without any dispute or without any hesitation.
No, Lordship. The second aspect of the matter, Lordship, the witnesses has deposed before the Leonard trial court, as well as the observation has been made in the judgment that she is a deaf and dumb, Lordship. Now,
Defend them.
yes, Lordship.
How the statement was recorded?
Exactly, Lordship. I fail to understand. And the law is very clear. When a witness comes who cannot speak, read and write,
How the statement was recorded?
interpreter
Mr.
or
Adnani?
Lordship, I don't know how exactly was taken, but they said that it's recorded.
No, where it is mentioned that she is deaf and dumb. She is deaf and dumb, where it is mentioned.
Lordship, the positions of the witnesses, as well as there is also observation made by the London trial court, Lordship.
Yes, which part of the judgment? If she was a deaf and dumb, then how can
Lordship.
court record her statement? Without taking help of expert
Exactly.
in
Lordship.
that line?
Yes, Lordship.
Yes. Where is the judgment?
If your Lordship may kindly allow me to take the Lordship to the deposition first, after that observation of the.
No,
trial
first
court.
you come to the observation of the court
Lordship.
in respect of her, in respect of deaf and dumb, being deaf and dumb.
Lordship. If your Lordship may kindly come to page 13 of the paper with Lordship. This points for determination, Lordship. Perfect. Evidence, Lordship. This is the evidence of PW1, Lordship. She is the cousin of the victim and the complainant in the instant case. She deposed that she was informed by the victim that on 3rd September 2013, at around 5 p.m., while she was taking bath in her house, accused Mrs. So-and-so came near her, so she shouted and the accused ran away. But after some time, the accused came back to her room, and when she was dressing, the accused pushed her down and raped her. At the relevant time, victim was alone. She did not disclose it to anyone. But the next day, when her mother was about to go for her business to the market, the victim told her mother that she should not be alone at home. Her mother made inquiry as to why she was scared. Only then the victim disclosed to her mother that the previous day, accused so-and-so raped her. Victim is physically challenged and innocent, Lordship. And as such, they believed her complaint. The victim is physically challenged, is also observed, Lordship. The victim is her cousin. So the victim's mother had called her to discuss the matter, and they decided to lodge the complaint. She exhibited the FIR lodged by so-and-so, and identified a signature therein as exhibit so-and-so. In her cross-examination, stated that the offense took place on 3rd of September. But complaint was lodged on 5th of September. She also reiterated that victim is physically challenged.
Where it is mentioned as defend dumb.
No, Lordship, I'll come to the other deposition of the other witnesses, Lordship. PW6, Lordship. If it, Lordship, can you turn to
Yes,
page 14, page
got
14, PW6.
Yes.
PW6 is a relative of the victim. She deposed that she is a technician and working in civil hospital Dimapur, residing at Half Nagajan. The victim is her relative. She heard about the rape on 4th September 2013. She went to her village in Chumukatima. The victim narrated the incident to her on 3rd of September 2013 at around 5:30 to 6 p.m. while she was taking a bath. Accused so-and-so came near her, but he disappeared. After some time, while the victim was dressing in her bedroom, the accused came inside her room and pushed her down, and while she was lying on the floor, accused raped her. The mother of the victim also told her that on 3rd September 13, at around 6 p.m., she came home from the market. The house was locked from the inside and the lights were off. The victim was in the house alone. The victim was not in the usual mood. She asked her what had happened, and the victim did not disclose anything. However, the next morning, when her mother was about to leave home for her work, the victim told her not to go out, leaving her alone. And she disclosed that the previous day, one of the neighbor of so-and-so tribe, who used to go and come by the road through their residence, came and raped her. The relatives in the Zeliang unit had discussed the matter. Since the victim is a physically challenged person, they felt that it was an insult and decided to pursue the case by filing complaint in the so-and-so police station. She deposed the victim is handicapped and cannot read or write, and person committing such offense against such a person should be punished severely.
Read and write does not mean that she is a defender.
Yes, Lordship.
Your submission is misleading.
Her deposition is not the major cross-examination. If your Lordship may kindly come to page 62 of the deposition, Lordship. Page 62, Lord.
Yes.
This is the statement of the PW6 in the cross-examination, Lordship. The second last cross-examination, Lordship. The second last. It is correct to state that the victim is deaf and dumb and that she cannot speak properly, but she is mentally sound.
But none other witnesses has stated to that effect. Victim is deaf and dumb and she cannot speak. Dumb means she cannot speak, but
Yes.
here she cannot speak properly. It means that she can speak.
Deaf and dumb is written, Lordship.
But she is mentally sound.
Mentally
And
sound.
it negate the
But
observation made by
that
the
is a statement of a layman, Lordship, but a medical expert, it says that she is mentally retarded, Lordship. So that shows that there is contradiction in the statement of the witnesses as well as the medical report, Lordship.
mentally retarded and deaf and dumb are two different.
Yes, Lordship, two different things.
Two
Now the
different
medical
things.
examination, it is the opinion of the medical expert is mentally retarded, not the statement of the witnesses. They say is that some handicapped, physically handicapped, and this particular witness has deposed before the London trial court that she is deaf and dumb, but she is mentally sound. So this shows the contradiction of the statements of the witnesses and the medical.
Even if we discard her evidence,
Lordship.
the evidence of victim is there. The question is, why should we disbelieve the version of the victim?
Lordship, the law is very clear. When a mentally retarded person.
No. Mentally retarded, there is no evidence. Mere opinion of the doctor who is not expert in that line, can it be taken into account?
But her statement should inspire confidence, Lordship. That is the
Definitely, there is no contradiction in her version.
settled principle of law, Lordship.
That is all right. You are right. Law is settled. But she is consistent in her version under section 164 CFPC. She is consistent with her statement before the court also. There is no cross-examination.
Lordship, there's a slight variation with the time, Lordship,
Maybe,
5:30 and 6 p.m. Lordship.
That may be natural.
Lordship.
Minor variation cannot be a ground for discarding the evidence of the victim. Mainly victim.
Lordship.
That is the subtle position of law.
Lordship. But when the medical examination has clearly stated that she is
Anyway,
mentally.
we will examine your submission.
Lordship.
Definitely.
Now, if
So, do you have any decided case law on that point?
Lordship, yes, Lordship.
You have?
Yes, Lordship.
Achha, you have given the list to.
Yes, Lordship. I think that is.
Achha.
2008, volume 15, SSC 1, page 133, Lordship. Paragraph 11, Lordship. Lordship, paragraph 11,
Yes.
page 141, Lordship. It cannot be lost sight of that rape causes the greatest distress and humiliation to the victim, but at the same time, a false allegation of rape
You're referring to page number?
Page 141, Lordship. Page 141.
Yes.
May I read it, Lordship? Para 11, Lordship. It cannot be lost sight of the fact that rape causes the greatest distress and humiliation to the victim, but at the same time, a false allegation of rape can cause equal distress, humiliation, and damage to the accused as well. The accused must also be protected against the possibility of false implication, particularly where a large number of accused are involved. It must further be borne in mind that the board principle is that an injured witness was present at the time when the incident happened, and that ordinarily such a witness would not tell a lie as to the actual assailants. But there is no presumption or any basis for assuming that the statement of such a witness is always correct or without any embellishment or exaggerated. Lordship, the next citation, Lordship, will be on whether the sole testimony of prosecutrix is sustainable, whether it inspires confidence, Lordship. 2006, 10 SSC, page 92. It was a 610 SSC, page 92, Lordship. Relevant paragraph is para 9, Lordship. Lordship will find paragraph 9 at page 95, Lordship. Lordship, got para 9, Lordship.
Yes.
It is true that in a rape case, the accused could be convicted on the sole testimony of the prosecutors. I totally agree, Lordship. If it is capable of inspiring confidence in the mind of the board, if the version given by the prosecutor is unsupported by any medical evidence, or the whole surrounding circumstances are highly improbable and belie the case set up by the prosecutors, the court shall not act on the solitary evidence of the prosecutors. The court shall be extremely careful in accepting the sole testimony of the prosecutors when the entire case is improbable and likely to happen.
So here only one accused is there. But in the other case, there
Yes,
are,
the first citation, there are several other accused persons.
and another thing is that is there any enmity between the accused and the victim so as to implicate him falsely in this case? Was there any suggestion?
Lordship,
No.
I cannot go
So,
beyond the
let us,
deposition, so there is no
Let
such
us see
statement.
the medical evidence.
Medical evidence, Lordship.
Yes, at page number.
66, Lordship.
No, the evidence of the doctor.
Lordship, evidence of the doctor, Lordship. Page 56, Lordship. 56, Lordship.
56.
56, Lordship.
Okay.
If your Lordship got it.
Yes, okay, 1 minute. So you see, the examination details are documented in the performa and found that there was a sign of sexual intercourse. Is evidence also supported her version then? Evidence of the doctor.
Lordship. Lordship, may kindly see the cross-examination of the doctor, Lordship.
Yes. And what are the other judgments you have relied upon?
Sign of injury, Lordship. No
Yes.
sign of struggle. Right, Lordship, take you to the citation on deaf and dumb person as a competent witness, Lordship.
It would not help you.
Lordship. Lordship, with regard to injury, Lordship, 2006 9 SSC, page 713, Lordship.
2006?
Page 9, volume 9, SSC, page 713.
713, para number?
Lordship, I'll rely on the entire judgment, Lordship. It is a short judgment. It's only 4 paragraphs, Lordship. May I read it, Lordship? From para 2, Lordship. The sole appellant was convicted by the trial court under section 376 of the IPC and sentenced to undergo rigorous imprisonment for a period of 10 years. On appeal being preferred, the High Court upheld the conviction and reduced the sentence from 10 to 7 years. Hence, this appeal by special leave. In the present case, age of the victim was only 8 years at the time of the alleged occurrence. Immediately after the occurrence, she was examined by so-and-so, who has stated in her evidence that no injury was found on any part of the body of the victim, much less on private part. Hymen was found intact, and the doctor has specifically stated that there was no sign of rape at all. In the medical report, it has been stated that vaginal smears collected and examined under the microscope, but no semen sperm detected. The evidence of the prosecutrix is belied by the medical evidence. In our view, in the facts and circumstances of the present case, the High Court was not justified in upholding the conviction. Accordingly, appeal is allowed, conviction and sentence set aside, Lordship. Your Lordship, may kindly allow me to take your Lordship to 2012 5 SSC 789, Lordship. Passion since 2012 volume 5 SSC. Relevant paragraph is para 9, 29.
Wait. Yes.
Lordship, got it, Lordship.
2012.
Lordship, 2012, volume 5, SSC, page 789, Lordship. Paragraph 29. paragraph 26 and 29, if your lordship may kindly allow me to that your lordship to paragraph 26, 29. Lordship will find page 797. 797, lordship. Para 26, may I read it, lordship. The object of enacting the provisions of section 119 of Evidence Act reveals that deaf and dumb persons were earlier contemplated in law as idiots. However, such a view has subsequently been changed for the reason that modern science revealed that persons affected with such calamities are generally found more intelligent and to be susceptible to far higher culture than one was once supposed. The view has changed now, lordship. When a deaf and dumb person is examined in the court has to exercise due caution and take care of ascertain before he is examined that he possesses the requisite amount of intelligence and that he understands the nature of an oath. On being satisfied on this, the witness may be administered oath by appropriate means and that also with the assistance of an interpreter. This is important, lordship. However, in the case a person can read and write, it is most desirable to adopt that method, being more satisfactory than any sign language. The law requires that there must be a record of signs and not interpretation of signs. Lordship, in the record, lordship, as well as in the judgment, there is nowhere stated that an interpreter was used or she was allowed to record it by writing it by her own, lordship, the statements, lordship. We fail to understand how these statements were recorded if she cannot hear it and if she cannot speak it, lordship. Now, paragraph 29, lordship.
The question is that why should we disbelieve the session judge who has recorded the evidence?
There are possibilities
why should we
when a procedure is laid down, lordship, under the statute, lordship.
Definitely, the court would have followed that procedure had the victim been deaf and dumb.
Lordship. However, it has not been recorded as such, lordship. In the record, nothing has been showed that. And when the medical report clearly states that she is a mentally retarded person.
No, mentally retarded, I have already stated. Mentally retarded and deaf and dumb are two different aspects.
Exactly, lordship. I'm on that too, lordship. Now, if supposing leaving aside the mentally retarded, lordship, coming to that deaf and dumb, lordship, if she cannot hear it and if she cannot speak, there is no record to show that
then how can
an interpreter was used.
How can all these persons have recorded her statement?
Lordship,
the IO has recorded.
That
the
is
doctor has recorded.
my prayer before this honorable
The magistrate has recorded. The session judge has recorded. Then anyway,
lordship.
Any other point?
Lordship. On the absence of raising alarm, lordship, and absence of injuries, lordship. Absence of injuries.
Not necessary.
Then in that case, lordship, I'll have to rely on some general principles of law.
Yes.
Lordship. Lordship, there is also observation by the investigating officer about her mental condition.
Where?
Lordship, may kindly allow me to take your lordship to page 24, lordship.
Paper book?
Yes, lordship, paper book. Page 24 of the paper book, lordship. The second paragraph, lordship. I am of the opinion, lordship. I'm of the opinion that rape committed by present accused is proved by the cogent and reliable evidence of the victim corroborated by medical evidence as well. Coming to the medical condition of the victim, the defense counsel argued that victim did not speak out about penetration and mere utterance of the word raped do not constitute the offense as much as PW3, Dr. So-and-so, and PW7 I of the case stated that victim was a mentally retarded and physically challenged person. The victim on the day of recording her deposition statement came to court with her mother on so-and-so. The court recorded her deposition in camera. Victim understood what was being asked to accept that she was dumb and cannot speak out. So this clearly shows, lordship, the mental state.
Who recorded this?
Lordship, this is the part of the judgment, lordship.
Part of the judgment.
Yes, lordship. This is the observation of the London trial court, lordship.
So where is the evidence?
Evidence of the IO, lordship.
Hmm?
Page 63, lordship. page 63 and page 64, Lordship, you will find in the cross-examination, Lordship. Cross-examination by the defense counsel, Lordship. It is correct to state that I am the IO of the instant case and I have filed the charge sheet in the instant case.
Page number?
64, Lordship. 6.
Yes.
If Lordship got it, may I take a Lordship only to do cross-examination, Lordship. It is correct to state that I am the IO of the instant case and I have filed the charge sheet in the instant case. It is correct to state that the result of examination is negative test for spermatozoa. It is correct to state that I have examined the body of the victim. I did not find any marks on the body of the victim. It is correct to state that the victim is in the stated to be mentally challenged as stated by her mother. It is correct to state that when I examined the victim, I found her to be mentally retarded. But the allegation she gave against the accused person was he had committed. So this is the observation of the IO of the case. It is correct to state that there is no other witness who had seen the accused, who has committed the rape except the statement given by the victim. It is correct to state that the accused had denied committing rape on the victim. It is correct to state that the accused was assaulted by the public before he was arrested. It is correct to state that the accused is a married man and his wife and has children. Next, Lordship. It is correct to state that there is no other evidence to prove that the accused has committed the alleged offense except the statement given by the victim. That is the cross-examination of the IO, Lordship.
Yes.
Lordship, the difference between may be proved and will be proved. Lordship. My contention before this honorable court is mainly based that my respectful submission, Lordship. He was convicted merely on suspicion. That is my respectful submission before this honorable court. And to rely on my submission, Lordship, if I may be allowed to take a Lordship to a citation 2013, volume 12, SSC, page 406. Four 406, Lordship. If I Lordship.
Yes.
Two 2013, volume 12, SSC, 406.
Yes.
Starts from paragraph 13, Lordship. Page number 412, Lordship. 412, Lordship. May I read, Lordship? Suspicion, however grave it may be, cannot take the place of proof.
That is a general principle.
Lordship, yes. I'm relying only on the general principle, Lordship. And there's large difference between something that may be proved and something that will be proved, Lordship.
Yes, Mr. Angami.
The case of the petitioner is because the victim is deaf and dumb. She cannot defend herself. She could not defend. She should not be relied upon because there was no victim with independent witness. Her case is not. That's basically the case with the appellant worship. But I think that learned court below has well observed. If I may take my lord to the judgment rendered by page 23. I'll not go into the other details except the relevant parts. Page 23, last paragraph.
Judgment.
Yes. This is the observation.
Yes.
Last paragraph. A plain reading of the statement of the victim before the IO, her account of the incident to her mother, to her cousin, the complainant PW1, to her auntie PW6, and her deposition before the court shows her testimony remains firm, unchanged, and without contradiction. She has maintained all along from the date of complaint till her examination in court that on 3rd September 2023, around so she was having a bath. Then she went up to her room to dress up. The accused entered her room at that time, pushed her to the floor and raped her. She must have undergone great mental trauma and anguish as she cannot speak, sitting in the dark in the house till her mother returned from the work in the evening. She was crying when her mother came back, but she was most probably in shock and could not tell her mother about the rape that evening. It was the next morning when her mother was about to leave home that she panicked at the thought of being left alone again and told her mother that the accused had raped her. It has to be kept in mind that reporting a case of rape is not easy for the victim or for the family due to the social stigma involved. And therefore, the testimony of a prosecutrix victim should never be treated lightly. In this instant case, the testimony of the victims corroborated by the deposition of PW3 Dr. Cesar, who has proved Exhibit P1, the medical report dated so, which states that there was erythema, redness of vulva, and evidence of recent sexual intercourse present. PW3 also proved Exhibit P2, the examination report of the accused stating that he is capable of performing sexual intercourse. It is also evident that the FSL report of semen, smear, and vaginal swab tested negative for spermatozoa as the sample were collected only after 48 hours of the incident. In any view of the matter, it is already settled law that it is not necessary that there should be complete penetration of the penis with emission of semen and rupture of hymen to prove the offense of rape. Moreover, I do not find any contradiction or any material discrepancies in the version of the victim so as to render her unreliable and unworthy of credit. I find that the victim has been consistent in her version, be it before her mother, the investigation officer, her cousin, or her auntie. I'm of the opinion that rape committed by the accused person is proved by the cogent and reliable evidence of the victim corroborated by medical evidence as well. Coming to the mental condition of the victim, Worship, I'll not repeat this since my learned have already read. I'll skip to the next paragraph. Applying the above position of law to the facts of the present case, it would be evident that the accused has indeed committed rape on the prosecutrix and that he is liable for conviction under Section 376, subsection 2, clause L of the IPC. The prosecutrix, being a physically challenged person who cannot speak. The fact that there has been penetration in the instant case is clear from the medical evidence, wherein the PW3 doctor has found that there is erythema, redness of vulva, and evidence of recent sexual intercourse. In fact, the doctor report on the basis of examination of the prosecutrix shows that there was recent sexual intercourse committed with the prosecutrix. There is no substance in the contention raised by the learned counsel for the accused appellant that in the absence of penetration, there was no rape committed on the prosecutrix in the present case. Next page. Defense counsel had also argued that in the present case, none of the PWDs could give any direct evidence other than hearsay statements. I am unable to agree with these arguments as well as all the PWs have deposed that they heard from the victim herself and not from somebody else. Even otherwise, in case of proving the offense of rape, uncorroborated testimony of the prosecutrix is sufficient. It has been held by the Honorable Supreme Court in the case of Census 1993 to SCC 622. There is no legal compulsion to look for corroboration of the evidence of the prosecutrix before recording an order of conviction, and that conviction can be recorded on the sole testimony of the prosecutrix. The court say there is no legal compulsion to look for corroboration of the evidence of the prosecutrix before recording.
Not necessarily.
Okay.
Not necessarily.
So, Worship, this is, I think this is.
Finding of the court.
Yes, very well, and there's no infirmity in this, Worship. And for the satisfaction from my lord, medical report, which the page 67. 67B. B, the third line. That is, I mean, second line, vulva for any injury discharge. Erythema, redness of vulva, this is already is there. Then hymen torn, all this there. Then coming to opinion, Lordship. Opinion below C. Evidence of recent sexual intercourse, yes. Accustomed to sexual intercourse, yes. And others also there, Lordship. So there's no infirmity. Yes, Lordship. Authority law. Even in the observation of the Honor Court is already stated, but 2004 SCC 379. This is with regard to the testimony as well as the penetration, that emission, rapture, all this. This is under paragraph 5, 6, and 7, Worship. Receive and 7. Worship.
The first one, paragraph number
5, 6, and 7.
Oh, you have marked it.
Yes, yes. Can you read again, Worship?
Okay. And the other one?
Other one is the observation of regarding testimony of the single testimony of the victim. Paragraph 31, Worship. I think I've marked it. This is 2017. This is C. 31. This is not. Shall I read it or do that? No. So in the light of this, I think that even the punishment was very lenient, the minimum only. So,
what was the punishment?
Minimum
10 years.
10 years, yes, minimum life. So I pray that as the learned court below has been the voice of the voiceless, dumb, the disabled.
You call the secretary? Yes.
I also pray that before your lordship to stand for the helpless, Lordship, in view of all these corroborated evidence in the law settled. That's for mine.
Yes, any clarification?
I've given the list of authorities that, which I've relied upon.
But you give the Xerox copy.
Lordship.
Xerox copy of the judgments you have
Lordship,
relied upon. Because it may not be possible for me to carry those records or not to those books to principal set, right? Heard, Mr.
Jamir, Lordship.
Learned counsel for the appellant, and also heard Mr. Kiangami, learned PP for the establishment. Argument concluded, judgment reserved.
Court to over.